Erica, would you mind if I took roll and then I can announce about the chair pro tem? Okay, great. So welcome everybody to today's Legal Services Trust Fund Commission meeting, Rules Committee meeting. Kim, would you mind doing, or Erica, I think you're going to do the housekeeping and then I'll take roll.
Sure. Good morning, everybody. Welcome to the Rules Committee meeting. Thank you for joining us. We're using Zoom with the goal to foster a more inclusive environment and effective meeting. If you'd like to comment during the meeting, please type "I have a comment" or "I have a question" in the chat, and a message will be sent to the host. Alternatively, you can also use the raise hand feature. In efforts of transparency for all those joining this public meeting, whether by phone or Zoom, we request that you refrain from having side conversations on chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you to virtually indicate that you'd like to speak in order to help the chair facilitate this discussion. Going forward, all commission and committee meetings will be recorded and posted to the State Bar website after the meeting. And a friendly reminder that this is a video conference, so please be aware of your surroundings behind you. If you're joining Zoom on a computer, when you're on mute, if you hold down the space bar, that will allow you to temporarily unmute if you'd like to speak. If you're using a phone to dial into this meeting, please be sure to use your computer's microphone and make sure that it's on mute to avoid audio feedback issues. And if you're joining audio via computer, it is highly recommended. But if you lose audio, you can call in separately to the Zoom conference number in the invite.
Okay, great. Thank you, Erica. So our chair, Amin, he's unavailable. He actually just had another baby a few weeks ago, so he's on paternity leave. So he asked if somebody from the Rules Committee could be chair pro tem for today. I did ask Erica preemptively to see if she would be available. So if we're in agreement, then may we have a motion for
Erica? Actually, I don't know if I can move since I'm a judicial officer, but
I'll move.
Okay, thank you, Corey. Do we have a second?
Catherine.
Okay, let me do roll call vote then. Oh, you know, I need to take roll first and then do the motion. I'm sorry, I did that a little bit out of order. Let me do roll first. Amin, Luis.
Here.
Catherine.
Here.
Erica.
Here.
Corey.
Here.
Jim.
Here.
Judge Seligman.
Here.
Great. And I'll do our liaisons. Christine Gonong. Mark Tony. Selena.
I'm here.
Okay, great. I saw you. And then State Bar staff. Erica Carroll. Judy.
Here.
Elizabeth.
Here.
Brady, are you on yet? Okay.
Heard him. I saw him. I didn't hear him.
Brady's here.
Okay, Brady's there. Okay.
Sorry, I was muted.
No problem. Okay, and now may we have a motion for Erica to be a chair pro tem?
I'll move.
Okay.
Catherine seconds.
Catherine second. Okay, I'll do roll call vote. Amin. Luis.
Yes.
Catherine.
Yes.
Erica.
Yes.
Corey.
Yes.
Jim.
Yes.
Okay, motion passes. So Erica, I will turn it over to you to call for public comments.
Okay, great. So are there any members of the public that would like to make any statements before we get started? I don't see anything in the comments either. Sir?
I don't see anything. I don't see anything in the comments too.
Okay.
Kim, are you getting any messages from members of the public who are on that would like to?
No, I haven't.
Okay, so I think we can move on. Are there any other members of staff or the commission that I missed? I think there's, Eric is on as a member of the public because he's part of a working group, but he's not officially on the Rules Committee. Hi, Eric.
Okay.
Hello.
So Erica, we can move on to then the next agenda item, approval.
Got it. Okay, the next thing will be the approval of the meeting summary and action items from the October 16th, 2020 meeting. Is there any discussion or anything that needs to be addressed on those? If not, is there a motion to approve them?
Make a motion.
Okay, great. Thanks, Jim. And a second? Everyone's so reticent.
Jim moved. Is there a second?
I wasn't there, so I can't.
Yeah, I wasn't there either, so that's why I was gonna.
Nor, I think you can still
I
second.
think, yeah.
a
a
I will
vote of confidence.
second. I wasn't there, but I think I can second, then I just will abstain.
Is that right, Brady? We can have a second even if you're not present, because you can vote, right? Even if you're not present. Oh, you're on mute.
Unmute.
Sorry, Brady, you're on mute.
Sorry, I was not paying attention to the intricacies of what just happened. What
So
is,
we have someone moved, but we have a member that moved, that seconded, that was not present. But I believe that's fine because you can
yeah,
vote.
yeah.
Okay. Okay, so the Catherine, I believe, second.
I
Is that-
did.
Okay, so let me do roll call vote.
Can I just, it seems like a lot of us were not present for the last meeting, and my understanding of the rule is that, I mean, a lot of people like to abstain if they weren't present, and on adopting it, and
Abstentions don't count for or against it, so
Right.
you, right? So it. right.
okay.
So as long as the majority of
So fast.
people.
As long as the majority of people vote, yes, I think
Right.
we're still good. Okay,
Okay,
and I'll do, and then, if we don't have enough, then we can just wait until next time. So
okay.
we can give it a try. Amin, Luis.
Abstain.
So let me just clarify, you don't have to abstain, right, Brady? You can vote yes. Unless you
Yeah,
want
it's
to
just, I mean,
abstain.
this is, and again, we use Robert's rules as a guide, but this is from Robert's rule sources. It's you can consider it a vote of confidence in the note takers and agreement with those who are voting yes.
So in light of that, Luis, would you still like to abstain or vote yes or no?
Brady says I can vote, so I'll vote yes.
Okay. Catherine?
I'm abstaining. I don't think I was even a member of the committee then.
Okay. Erica?
So I also wasn't a member, but I will vote yes in reflection of the confidence as to
Okay.
the minute takers. So yes.
Corey?
Same, I'll vote yes.
Okay. Jim?
I vote yes, and I was there, and I can attest that the minutes agree with my notes.
Okay, great. So we have 4, so motion passes.
Great. Okay. Sorry, Dawn, go ahead.
We're on to the business, Erica, but before we get to the business items, can I just make a couple kind of administrative announcements about the work plan?
Please.
If you don't mind. So we had to rework the work plan a lot for this year because some of the items that we thought we could prepare for the February meeting, we were not able to prepare, and one of the items for this meeting we couldn't. So we still have a pretty full agenda today, but we had to rework it. The latest development that has surfaced is we've been getting a lot of inquiries from programs about how to handle expungement. Brady has pretty much concluded his analysis, and that will be presented to the commission at the June commission meeting. But we think the best course of action might be for this year, maybe a stopgap measure while we take it through codification. So we'd like to move up the issue of expungement in codification so that programs have some type of resolution. There are a lot of programs that have been counting expungement and other kind of collateral work as qualified expenditures or not. So they would like some type of resolution. So in light of that, we would like to propose staff to the Rules Committee to really expedite that topic and move it along up so that it can go to the Trust Fund Commission and the Board of Trustees before the next application cycle. So we usually release the application around April every year, and it's due in May. So we'd like a resolution for the community in advance of next April, but it's a pretty lengthy process in order to kind of just initiate it. the drafting of the memo, then it needs to go to the rules committee, then it needs to go to the commission, then it needs to go to the board of trustees, then they send it out for 60-day public comment. So in order to even have a fighting chance, we would have to at least meet on expungement, the rules committee in July. So I don't know if people have thoughts on that, but that would be our strong suggestion, is to move up that topic, but it does impact kind of the rest of our work plan. It pushes everything down in addition to us being delayed on a few topics.
So Dawn, it's Catherine. I think it's fine, although I'm not certain what expungement of people's criminal, could you give me some context?
Yeah.
Just 'cause
So
I'm
it's
new here,
mainly
but-
expungement of criminal records, but then there are a lot of kind of collateral issues that legal services provide with along with that. Record clearing. Sometimes there's like an entire their practice, they do like fines and fees. So somebody that has a lot of traffic tickets, getting rid of.
I got it. So is it just a question of whether those are qualified expenses and they're civil, not criminal? Is that the
So
gist
the
of it?
underlying question is whether they're civil or criminal.
Perfect. I got it
Brady's
now.
looked into
That's-
it, and there's kind of preliminary analysis, and Brady's going to finalize in a memo for the commission that OGC thinks it's criminal. So there's that question. So there's a provision in the statute that says that we cannot fund any activities in criminal proceedings. So we've already notified programs last year that they cannot use IOLTA and EF funds for expungement work, because the OGC's preliminary reading is that it's criminal. So the programs have already carved it out for 2021, but there's a bigger question of, can they count it for qualified expenditures?
Correct.
That gets a
I
lot
got it.
stickier,
Yeah.
because it's going to impact grant awards, and potentially some programs that engage in a lot of that activities can be found might not be primary purpose and might not be funded.
And
However, there's the statute though is very clear on that. We can't use IOLTA and EF money for anything, any criminal activities, but they don't have a definition of how we count as qualified expenditures. That's all in our guidelines, but our guidelines are clear in that you have to deduct if the activities are not civil legal services. So there is some reading, and there's some interpretation there that we think that there could be kind of a 1 year kind of provisional interpretation while we kind of think about what we want to do for the long-term codification. So that will be the recommendation, and that'll be a commission decision of what to do for the year. And then the rules committee will be responsible for crafting the more long-term policy decision of how do we deal with expungement and all those other collateral activities.
Juan, Selena has her hand raised.
Yes, Selena.
I just have a quick question about what programs should be doing, or is it status quo for the year 2021 where they count it as QEs?
So we have an email coming out literally today to say that, this is going to go to the commission as the short answer, but the staff's recommendation in consultation already with Brady and the Office of General Counsel is that for this year, we let programs counted as qualified expenditures because there's a reliance factor on it. But again, we can't make the determination, Selena. It is going to go to the full commission in June.
So programs, at least for now, should be counting it, but in June, they may.
Well, and yeah, so what the email will say that goes out today is that for now, because the application is due after the commission meets, for now, count it, but we would like you to segregate those funds in the event the commission doesn't agree with the staff recommendation, that there's a mechanism that you can quickly then back out of it. But for now, the instruction for the application will be to keep it in, and that's the staff recommendation.
But that would be for their 2020 QEs, because their 2020 QEs is what they're reporting.
Yeah, that would be for their 2020 QE, which is what they use as a base to apply for 2022 award.
Got it. So would there be a situation where programs who had their everything running as normal in 2020, they turn in their applications in May, and the commission in June says don't count it, where programs would have to go out and exclude their QEs from their QEs 2020 expenditure?
Yes, there is that
Okay.
possibility if the commission doesn't approve with, is not going to approve the staff recommendation.
That may be pretty tough for programs who did a significant amount of expungement work in 2020, and then now, in the spring of 2021 are being told it wouldn't count.
So
Look
yeah,
like that could
that's
be-
on balance, and that's why that's the staff recommendation. But the commission will, I think, on what balance and weigh all the factors. And the email that goes out, and I'll share it with the rules committee once it goes out, does say that we will notify the programs and keep them apprised of all the meetings that we'll be discussing this. So Selena, you're welcome, obviously, to always come and make comments on behalf of the community. If there are programs that would potentially be impacted, then they are also welcome to come and make public comments.
Okay, thanks. Yeah, I think everyone's aware that because of LSC has decided that expungement work would be qualified. I think a lot of the LSC funded programs would probably get bring a memo from LSC in support of.
Yeah, and that's part of the analysis that Brady will be sharing with, and I don't want to steal Brady's thunder, but what OGC's come out with is particularly to that advisory opinion from LSC is that it's not governing. I don't know, Brady, if you want to say anything more.
Yeah, I mean, so and the one thing we should be clear about is 6223, regardless on what comes out with qualified expenditures, is that our funds cannot be spent on criminal providing legal services related to criminal proceedings, and we've already informed the programs that includes expungement. You can't use the money we give you on expungement. We went through this last year, and we don't agree with the LSC analysis. It certainly doesn't apply in California, where an expungement is a dismissal in your original criminal proceeding. We went through this with Justice Murray. This can't use our funds. That would be violative of the statute. What's under consideration is that the statute itself does not specify that qualified expenditures must be based only on civil legal services. It actually says that qualified expenditures are based on your expenditures on legal services for the indigent. And it's actually a guideline of the state bar that adds the civil requirement. So in that area, we do have, because it's interpreting our own guideline, perhaps a little bit more leeway than we would in the statutory provision, which says what you can't spend our money on. So that's why staff is going to be making the recommendation to continue our current practice as far as qualified expenditures, and then looking at changing that guideline.
And also to add, we have had conversations with our executive staff as well as Selena, whether if programs have been treating expungement and other kind of related activities like civil, should we just, the cleanest possible route might be to just have a statutory change, and then that's very clear, crystal clear, we did have some conversations with Selena, and it didn't seem like there would be consensus. And Selena, I don't want to speak on your behalf, but maybe you want to give a summary. There might not be consensus at this moment for statutory change, and that's why that hasn't been moved in that direction.
Yeah, I think we would want to just have a little bit more conversation with with a legislative staff to see if now's the best time to do it. I think my other kind of remaining question is expungement the only example of something that you can't use IELTS or equal access funds for, but also you do allow it as a QE, or are there other good examples of something that a type of service that you do allow as a QE, but you don't allow IELTS funds to be used for?
I think infractions would be another.
Infractions. And there's one more, I think Erica in our office.
There's also traffic.
Talked, right? There was another example I think you brought up to me, or Erica, that sometimes we.
I don't think we'd actually made it.
Okay, maybe I missed. Okay.
We've gotten questions about other areas, but I don't think there's any there's some we still need to look into.
Yeah.
Thanks.
Okay, so let me just share really quickly what the high level, what the calendar would look like. So I'll be sending this out to the Rules Committee as well as the community if everybody's comfortable. So for this meeting, we'll talk about pro bono allocation exchange funds. The next one will then tackle the pass-through funds, which is the one that was supposed to be on February's meeting, as well as the law school clinics. And then July is when we would talk about expungement infractions and the other non-civil areas of law, as well as how to deal with RFP review process for discretionary grants. Then in September, we're going to roll back to primary purpose for QSBs and how to define civil legal services. And these are two topic areas that, as you recall, in October, we had pretty, I think, detailed recommendations. We were just waiting to see kind of the direction of the statutory change. And it looks like there's a good possibility that this cycle, we might be able to change the statute to increase it to 200%. So the working group that worked on these two particular issues wanted to hold off. But I think at that time, we should have, if not the change in place, or a good indication whether it's going to happen. And we'll try to finalize that recommendation to then take to the commission. And then, as you recall, one of the first topic that the Rules Committee tackled was audit. And it was whether to include kind of pro bono services in the accounting of audits. But we held off on finalizing that recommendation because the law school clinic issue also has some audit issues that we wanted to tackle law schools before we finalize audit. So we'd like to then, after law school, take back the audit issue and really finalize that. And then we'd like to close out this year with some fiscal technical kind of issues in terms of how to count out of county expenditures, carryover and budget modification policies, indirect costs for both law schools and QSPs, as well as support centers, and how we run the IELTS formula. There's a way that we do it in the office. It's not codified, and we'd like that to be codified. And then next year we'll tackle, it's in the work plan, but this is just a glimpse for this year. Next year, 2022, we'll tackle some of the other administrative issues, law, support centers. We haven't dealt with a lot of support center issues, so that'll be for 2022. So let me stop sharing my screen and see if people have questions or are comfortable with the new plan.
Anybody have comments? I'll just note, it sounds like this expungement issue is, kind of high priority for the various organizations. So it seems like us addressing it on a quicker timeline would be beneficial for them. So I at least advocate that we move it up.
Okay, thank you. Thank you. Yeah, that we strongly recommend it. We even contemplated for the June meeting, but I think that might be a little bit tight for us because Erica's the lead staff that's going to be working on this issue with Brady. We'd like to kind of send out a survey to the community and see kind of what the universe looks like and how much programs are doing for expungement, other issues, so that we have kind of a handle on the expenditure side before we come with a recommendation.
So do I need a motion from us or anything?
You don't need a motion.
Okay.
I just want to make sure everybody's comfortable with the plan.
Okay.
I just ask one question. So if we do this in July, that works okay for the determinations that, so programs are submitting it? I mean,
so it's two different. This particular Rules Committee is tasked with like the whole codification process and the long-standing policy. The stopgap measure for just the 2022 application is actually going to go to Eligibility and Budget Review Committee and then go to the commission. But we don't, there's a little bit of a timing issue that Erica, Carol, and I have to work towards, because I don't think we're gonna have time to build into the eligibility and budget. So we might need to bypass and go straight to the commission with this in the June meeting. But technically it should go to Eligibility and Budget Committee and then commission. It's just, I don't think we're gonna have time.
Got it. So we'll be seeing the stopgap thing again,
Yes.
the broader one, but as far as like how we should codify for this committee, yeah.
And what you do for this year might not be what you ultimately do for the long-term policy.
Right.
But really for the stopgap measure, I mean, we a lot of these programs have been our grantees for 20, 25 years. So there's on balance that consideration of not really wanting to impact services. The long term, though, I think you'll have to take in other factors into consideration.
Right. Okay. Have we traditionally allowed expungement Has
We
it-
have, and
Okay.
that's why we have, and it was always under the rationale that with expungement work, it enabled kind of a civil remedy that they were also assisting in. A client comes through and they have, they're there and they need to apply for housing, but they have to be able to expunge their records in order to have that housing application or other kind of related work. So that was the argument that not only staff, but the commission has always used that rationale in order to deem it qualifying services.
Right, but arguably that's inconsistent with the guidelines.
It's inconsistent with the guidelines and arguably, and Brady will share this when he does analysis. I think there's case law too, so.
Okay.
Yeah. I mean,
cool.
you could apply that rationale to, well, I should prevent you from help you not get convicted of a crime.
Yeah, exactly. There's lots of criminal things that prevent civil things, so totally. Okay, all right. Well, we
So
can.
it's pretty sticky, and that's why we thought maybe a statutory change might be the cleanest, but it didn't seem like at least this past year that it was ripe for that.
Perfect. Okay.
Okay.
Well, it sounds like we'll be addressing it very soon. Are there other administrative things that you wanted to talk about, Dawn?
No, that's it. Thank you, Erica.
And then Selena, I saw a comment that you might want to provide us with an update on action since the last meeting. Did you want to provide that now?
Sure, and Catherine also can make it. At the last meeting, which Catherine wasn't at the last Rules Revision Committee, we discussed the proposal to move to 200% for IELTS eligibility. And there's been some movement on that. Catherine, did you want to make the update or would you rather I do it?
Oh, go ahead. You're doing great.
It's so weird to not have my video. Yeah, so after that meeting, we talked with legislative staff and Senator Umberg, who is now the chair of the Senate Judiciary Committee, was already looking at IELTS eligibility for veterans, trying to increase eligibility for veterans who receive disability benefits. And so we worked with Senator Umberg's office and with his staff. And so now the current bill is that IELTS eligibility would be expanded to individuals based on their income up to 200% of the federal poverty level rather than 125%. And additionally, veterans' disability benefits would not be calculated as part of the income. So that means that kind of lower income households where maybe one member will receive disability benefits, that would be kind of carved out for their income. And I don't think this bill is controversial at all. I think it's going to get a lot of support. So I think by the time the Trust Fund Commission meets again, the full commission, we probably will have an update that the bill has kind of is chugging on along. So just wanted to give that update to this group since we talked about it.
Selena, when will we know, like definitively, I guess, or?
Not until the fall when either the governor, vetoes it or signs it or ignores it. There's plenty of time for bills to get through the House of Origin and then on to the second house. Most of the action on policy bills happens kind of in the summer.
Okay, great.
And there were already there was at least already one hearing on the bill and it came out of committee fine without any problems. And I think it is in another committee already, which I believe there may be a hearing on that. Maybe the hearing in the second committee already happened too. I'll check.
We did have a question from Eric about when would that change be effective if the bill passes?
I think that would rely on your interpretation, State Bar staff, because it would be, the bill would become law on January 1st, 2022, because it's not an urgency bill. So it would become law on January 1st, 2022. And so you could either direct programs that they could, start counting as of January 1st, all of their clients above 125 up to 200%. I think it would be politically tough if you told programs that they could go back when in 2022 they report their prior year QEs, the current year we're currently in, because I think a lot of organizations already do some work, over income, and so I think it might not be equitable. I will say it that way. That it would be hard to go backwards looking and tell organizations that they could count the work they'd already done if other organizations were not on even footing. But forward looking seems like it should be fine.
But if you counted for 2020, oh, sorry.
Go ahead, Dawn.
I was gonna say, if you counted for 2022, You actually don't use those expenditures until you apply in 2023 for 2024 funding, if I'm thinking about it correctly.
Could
Yeah.
the statute just specify?
That's exactly, Brady,
Yeah.
that was gonna be my comment of, I thought that was a really excellent question, and wouldn't it be clearer if the statute were amended just to reflect the effective date? Because I think otherwise the effective date is January 1st, and how do you say I can't count an expenditure when a statute effective January 1st, absent some later date? I mean, it just seems, I think that, I don't know that I think that's just an interpretation question.
Right, and it would seem, I mean, arguably, I'm trying to picture how this would work in the statute, but arguably, unless the statute said, unless this amendment said something new, then all of our payments going out beginning January 1st should reflect the new calculation, which would involve recalculating, from two years ago.
So it is already out. It's moved on to the assembly. So it's now in the second house. And so when it gets over, it hasn't been assigned yet to Assembly Judiciary. When it's assigned to Assembly Judiciary, we can talk to staff over there and say that, an amendment to clarify the effective date would be really helpful.
Yeah, just
and not just the, like, the
the
effective date is like, which years, what does it mean to be effective on
Right.
January 1st? Like, everything we do from now on should reflect the new calculation, or did the payments that we're making in this grant year need to reflect?
So you don't want the latter, and
Yeah.
I think though you should set a date that maybe coincides with the grant year as to when those expenditures for 200% of poverty level are going to be counted. So we're not going to solve that today, but maybe Selena, Brady, and Dwan should come up with some proposal in the bill that figures that out, like what's reasonable.
Yeah, I mean,
You're going to
Selena-
want to propose specific language,
I
probably.
agree with that.
Yeah, I was gonna say, Selena,
Very
maybe Brady and I can draft something that you can have at your fingertips to.
Yeah, that sounds perfect. I'm going to reach out to staff now and see who's going to staff it. With over an Assembly Judiciary Committee, it could be a number of different people. So I'll find out who has it and let y'all know.
And they're going to be fine with it. Most likely they want to be helpful. So
Yeah.
it's a good place for the amendment to be.
Great.
Okay, great. Selena, thanks for that update, and thanks for the really helpful discussion on this stuff. If we're done discussing that issue and there's no administrative updates, I guess we can get into the meat of our meeting today. The first one is to discuss and potentially approve the recommendations regarding the pro bono allocation tests. I'm not sure, I can't remember if I said I would present on this or if someone else is presenting on this, or.
Staff has it handled, but the working group is welcome to chime in and provide feedback.
Okay.
I just want to thank both Erica, Carol in our office, and Judy McManigal for putting together this really excellent memo. Judy's going to take the lead presenting it, and the rest of the staff will provide support. And obviously the working group members, please do chime in.
One thing I would like to, before we dive into it, is the expectation that we will do like motions as we go on the recommendations, or do we want to do like one omnibus motion at the end? Do you guys have a suggestion on how to do that?
Our thought was one motion at the end, but there are a lot of decision-making points. So we would like feedback along the way.
Okay, that's fine. I just wanted to make sure.
But we defer to you, Erica. If you
No, but an omnibus at the end, if it looks like there's, something that requires any major divergence from the recommendations, then we can have a discussion at that point. But
and we'll pinpoint kind of where some of the sticking points are that maybe require a little bit more discussion, whether either we weren't quite in agreement with the community's recommendation, or else we were unsure, and we would like your opinion.
Perfect. Okay, I'll turn it over to, I guess Judy's going to take the lead.
Yes.
Thank you.
Yeah, great. Thank you. Let me get it up here. Okay, there we go.
Okay, we do have a lot of material to cover, so thank you for joining us. I'm going to go through it fairly quickly. And then after each segment, we will have time for discussion, questions, etc. But I'm just going to launch. So we're considering elements today in kind of three big categories. Whether we want to eliminate or modify the threshold test, which is also known as the substantial numbers test, then clarifying definitions within the eligibility guidelines, and finally modifying the principal means tests, otherwise known as tests A, B, and C. And there are several options within each of these three larger categories. So just a super quick review of the authorities that we draw from. The ULTA statute is where the funds formula is designated, setting aside 10% of LSP funds for those that recruit substantial numbers of pro bono attorneys and their principal means of delivering legal services via pro bono. However, the statute does not define substantial numbers or principal means. So we go to the guidelines for that. They outline the tests for these two principles. Here's just a quick visual summary of the threshold test. The QLSP needs to recruit at least 30 attorneys or recruit 5% of the attorneys in the county where they're applying for the allocation, or their pro bono attorneys have donated at least 1,000 hours. And important to keep in mind is that even if you don't meet this test, if you do not meet this test, then you cannot proceed to the second part of the test, even if you meet those elements of the second part of the test. Now, kind of taking a step back as to how the threshold test is applied, there's really, a wide range of the number of attorneys available for recruiting. Los Angeles, for example, their county has more than 56,000. Napa has 439. Alpine has 3. And the composition of the bars in various areas is also very vast. In smaller rural areas, the bar may consist almost exclusively of the DAs, the public defenders, judges, and attorneys who work for our nonprofit organizations. And the types of firms also vary. Rural areas are primarily small and solo practices, where the urban centers have more attorneys, more law firms, and also more law schools. So the options we're going to be considering are eliminating the threshold test, using a scaled ratio for the threshold test, establishing a more flexible threshold test, or maintaining the threshold requirement as it currently stands. And then we can discuss them all holistically after taking a look at all 4. So first off, the threshold test, there are a couple of arguments here. There is no requirement that there be 2 separate tests for the substantial numbers and the principal means. And the threshold test does not account for dramatic differences between counties, both in the number of attorneys and the types of firms in those counties. The test also does not provide a realistic opportunity for some of our organizations. In 20 of our counties have fewer than 100 attorneys. There's still, however, a pressing need for legal services, especially in rural areas. One thing the working group considered is this test is redundant in that substantial numbers can still be adequately measured through the principal means tests, those tests A, B, and C. And there are organizations that meet tests A, B, or C, but they're disqualified simply because they don't meet this threshold test. So option 2 would be using some kind of scaled ratio, keeping the threshold test, but in a modified form with a proportionality. And the entire methodology for this particular sample is laid out in attachment B, if you're really interested in excruciating detail. But the summary here is that we divided the number of active attorneys into these various bands. and then we proportionally took percentages of the numbers that they would need to recruit or the number of pro bono attorney hours that they had. Now, there's another kind of scaled ratio that we could use based on perhaps the number of attorneys employed at an organization versus some minimum number of pro bono attorneys or pro bono hours. And this invites equity in assessing really what constitutes a substantial number for diverse areas, but there are really some concerns with this option, in that specifically applicants have different metrics if they're applying in more than one county, and that adds to complexity in tracking. A county might have different metrics from year to year if the number of active attorneys changes, and it would be difficult for organizations to plan without knowing what those metrics would be. Then moving to option 3.
Judy, this
Yeah.
is Jim. I also have a comment. I mean, I didn't realize that you were doing the presentation. Most of my comments are sent to Dwan and Erica. But one of the problems with that whole approach was it did not take into account differences by rural versus urban, which I provided analysis. The other thing it does not take into account is the ratio of active attorneys to people at the 200% or lower poverty level.
Exactly. And actually, Jim, I did receive all of your expansive research, and we do have a couple of slides coming up in just a minute that address specifically those issues.
Okay, great.
As part of our decision-making process, because it was incredibly valid and really point on what we're discussing today. And that really takes it to a whole new level. And that is probably ultimately what would be required. So we'll get back to that in about 1 minute. Thank you. So in establishing a more flexible threshold test here, I point out that there is a narrative option in that test C in the principal means tests, but not in the substantial numbers test. And there's really no rationale for allowing flexibility in one and not the other. And the guidelines for substantial numbers do provide us with a list of relevant factors. It's, saying as long as you meet one of the 3 minimum requirements, you can demonstrate your recruitment of substantial numbers using these following factors. So the guidelines could be changed so that numeric tests are sufficient to satisfy the threshold, but failing to meet one of those, that the organization could then still provide a narrative response regarding these enumerated factors. Because the way the test is currently set up, failing to meet the threshold means that you're disqualified from even moving to step 2 with tests A, B, and C. And this denial really seems contrary to the IOLTA statute, because the statute wants to provide additional funds to organizations with a substantial number of pro bono attorneys, where the principal means is pro bono. And then finally, option 4 would be keeping the bright line minimum where it is today, so that we can determine, who merits that additional funding. And carving out exceptions may eventually swallow the rule. So those are considerations for keeping it as it is. The response from the legal aid community was that their first choice was option 1, to eliminate the threshold. Their second choice was option 3, to make the test more flexible. And they felt that requiring programs to meet minimum numbers, either hours or persons recruited, is not equitable due to the significant differences that we've seen in staff size, in the location of urban versus rural, and in service delivery models, which really have different requirements. And then we have the additional analysis here that Jim referred to. This points out, perhaps more importantly, what we need to be looking at is not simply the number of active attorneys, but the ratio of persons who qualify for legal aid versus the number of active attorneys. And he's broken it down here into the 4 types of areas in California. And you can see, the discrepancies vast, 52 minus 289 here. And then I took his data and I broke it down even a little further. I took 2 counties from each of those 4 bands, and the differences are even more stark. 10 residents per attorney in San Francisco versus 735 in Glenn County. So this data really points out why some rural programs may perceive themselves at a disadvantage with these bright line requirements. And option 2 that we had discussed above offers that graduated minimum requirement based on active attorneys, but this option is not preferred by the legal community. And if the Rules Committee decided to pursue option 2, we would really want to consider this more extensive analysis of residents per attorney rather than just the number of active attorneys per county. Then moving on to the recommendations from the working group, their recommendation is to eliminate the threshold test. And that's based on consideration of the community's feedback, the fact that it would be more equitable and simple, and that recruiting substantial numbers of attorneys can be met through modifications to the principal means test, that those tests really can be, put together and be one in the same. So those are the 4 options for threshold. And Erica and Dwan, I'll defer to you whether, because there is complexity in a lot of these, whether we want to discuss this bucket now or wait until the end once we've gone through all 3 buckets and start our conversations at that point.
Unless Dawn, you have a different thought. My suggestion was to do a little bit of discussion as we go, just to get a read. We can always continue the discussion after we've gone through everything, but I would, do any of the committee members have any thoughts on the working group's recommendations?
Yeah, one comment. Even though I suggested an alternative way of doing the sliding scale, I just want to say for ease of application, and I agree with eliminating the threshold, the option 1 approach. Also, in light of the fact that as far as I can determine, and as far as staff could determine, there is no data-driven rationale for the original threshold requirements to begin with.
I agree. I think you've compellingly shown how the threshold test is kind of silly. It makes no sense and is very deleterious to the rural counties. I would, and anticipating where we're going, I think that with regard to the principal means discussion, I think we should explicitly put in one factor, what I'll call the meeker factors, considering the ratio between the attorneys and the indigent population, and explicitly noting rural versus non-rural, because that's one of our goals, is to address the lack of resources for rural.
Yeah, I'll just note, so I was on this this working group, and I endorse the recommendation, but with the caveat that I do think if we're going to collapse them into one consideration, we should add in the test, either, when we get to the principal means test, we should add something that discusses substantial number of attorneys and some explanation, whether it's, Judge Sligman, as you recommended, the meeker factors, explaining the rural versus whatever, but I do want to make sure we have something that addresses that. So, but I think there's no reason to have them separate. So Corey, you have your hand raised. What's up?
Yeah, basically I'm just agreeing with you. I think you can have a single test, but as long as it expressly addresses the factor of substantial numbers of attorneys, and just with regard to dealing with the equity issues for rural and urban. Obviously everyone on this call cares about this a lot, but I do think we also have to make sure that we're following the legislative intent, which is that it really be a substantial number. And we can talk more about what that means when we talk about the other the principal means test and combining it into a single one. But I mean, in some of the counties, if I don't think one, for instance, would be considered a substantial number by the legislature. And just to give an example, no matter how rural the county, it's to some extent, it may be that the statute does have a bias towards urban areas. And I do think we should all consider equity, but we still have to carry out the legislative intent, whether or not we all agree with it.
Right. Well, this was something hypothetically, if we just got rid of the threshold tests and left the principal means tests as they are, theoretically, you could have one staff attorney and two pro bono attorneys. And as long as the pro bono attorneys, their hours outnumber the staff attorneys, if you're in LA County, you could qualify. So we want to be a little bit thoughtful about, what we're doing there. So Catherine, you have your hand raised. Oh, I think you're still on mute.
So much to manage here. So on that one chart that was doing the gradations, and it essentially on the far right said, like, the volunteer attorney donated 10 hours of pro bono time. I mean, I guess this just goes to the point of why that chart and why maybe that initial standard of the numbers doesn't make sense, because that's sort of saying if you had 10 hours of pro bono time, that would be sufficient to establish that that's your principal means, I guess, of providing legal services. And that's not very much time you're getting out of a pro bono project. So I guess I'm just supporting it, but was kind of struck by that chart, unless I'm misunderstanding what that portion of the test was designed to do.
Which chart exactly are you?
Yeah, which one are you thinking about?
Hold on, I got to go back and find it.
Are you in the PowerPoint, Catherine, or the memo?
No, I was in the memo. Option 2.
I'm happy to scoot back.
Is it this chart, Catherine?
Hold on.
Oh, she's talking about this chart about how many hours, the scaled version.
Yeah, I mean, it just seems like active attorneys in the counties, all you would have to have is 10 hours, right?
Mhm.
I'm not really disagreeing. We don't need to spend a lot of time on it. I guess I was just struck by that chart saying that the numbers of pro bono volunteer hours to meet that threshold test were low.
Yeah. And this was just based on percentage, because where the first band was an X percentage of the top band. So that same percentage then was used to compare the number of volunteer hours that would be required.
Yeah.
They have 1% of the attorneys, so they need to provide 1% of what the requirement is for that top band.
Right. I understand how the math was calculated. I guess I'm just speaking to the fact that I don't think that option really fulfills the statutory intent of trying to measure what the impact of pro bono is, and the number is so low in terms of the number of volunteer hours. It's kind of to Corey's point, I guess, you can't, how do you show that that's meaningful if the threshold is so low, even if that threshold is reasonable when you're doing it on a pro rata basis? So I'm really agreeing with what everyone said, is that's not a solution to this particular part of it.
Yeah, agreed.
It also shows how kind of pointless the current threshold of 5% of the licensed attorneys in the county who provided services, what that means in a very rural county, that it could mean.
Well, what does it mean in Alpine County?
It could mean one or two attorneys.
We have 3 lawyers in Alpine County. 5% of 3 lawyers is
right. Exactly.
Less than a lawyer.
I think it seems that the threshold test gets way into the weeds before we even look at the rest of the qualifications for the getting the grant. There's a whole lot of data here that we haven't even looked at the bigger picture, and the other options give us a bigger picture of how to be consider more of the information and make a thoughtful decision instead of a decision that's based on all that data.
Catherine, did you have another comment?
Nope, I don't. Thanks for asking.
Any other comments or thoughts from the members of the committee or anybody else for that matter?
Just that maybe I should check out home prices in Alpine County.
Indeed.
So it seems as if, and it sounds like we'll probably handle a motion at the very end, but just to make sure I'm taking the temperature, it seems as if most of the committee is on board with just eliminating the threshold test, adopting the working group's recommendation. Is that where people are?
Yeah, this is the proposed motion.
Right. I will say, like I said, I'm supportive of it, subject to us tweaking the second part of the test to make sure we are continuing to address substantial numbers, but in a collapsed form in some way that gives us more flexibility. So I will make that point. Okay.
Exactly.
Judy, should we hold off on in case some of the other discussions might impact this, even though it does seem like I'm getting the sense that people are comfortable.
Yeah,
okay.
I would suggest we don't do a motion at this point because we're going to consider the next test, and I think these things play together. So if you don't mind, maybe we can continue with the discussion and then kind of try to figure out how to make a recommendation that's more collective.
Duan, just a question. I just want to make sure everyone's aware that the threshold, the substantial number test also exists separate and apart from the pro bono allocation, in that it's a way that certain qualified legal services providers can establish eligibility as a QLSP in the first instance.
We didn't point that out. Maybe you could speak a little bit to that too.
Sure. So if you look at, let me pull up the statute.
I think it's
The statutory, to be a qualified legal services project at all, under 6214 of the Business and Professions Code, you can either be funded in whole or part by LSC or the older American Act funds, then you're cool, or you need to show that you've received cash funds of $20,000 per year to support free legal representation of indigent persons, demonstrated community support, and then either coordinate recruitment of substantial numbers of attorneys in private practice to provide pro bono work, or provide legal representation to special client groups such as the elderly, disabled, juveniles, and non-English speaking groups. So separate and apart from the question of how we establish eligibility for the pro bono allocation, the substantial numbers of attorneys concept needs to remain, because that's a way that grantees can establish eligibility as qualified legal services projects in the first instance. And Duan, do you know if anybody, are there grantees that
there's not, so that has it in the statute, and Brady's correct, but we don't have further kind of commentary in the guidelines. So there is a spot in the application that programs can, but because there's no kind of guidance to it, we don't apply kind of the same substantial definition that we do in the pro bono allocation test. So a program, and not that I can recall, has whether they've exercised it or whether we've scrutinized it, because it hasn't come up, Brady, in terms of context.
Are there any grantees that only establish eligibility under that, or is every grantee
not that I can recall. Not that I can recall. Yeah, it's because the other ones capture most, if not all.
Sorry.
Oh, sorry. Go ahead, Erica.
Sorry, I just want to make sure I'm understanding the concern here. So Brady, is your concern that through this other means, entities were using the threshold test as a way to qualify under that. So if we got rid of the threshold test, they wouldn't have a way to qualify as a QLSP. Is that your concern?
Well, it's that the statute does say that is a way to qualify, and so so I don't know that it's ever used. It sounds like probably not, and
it hasn't tied back. So think for us the issue in our office is that, you know, for the substantial numbers, we have this threshold test and the pro bono allocation. So there's a part of the statute that also talks about substantial, you know, numbers, but there's nowhere in the guidelines that talk about that in terms of eligibility. So the staff hasn't applied that definition in context of pro bono to the piece that's eligibility. So,
well, actually, that's not true, because the guidelines actually discuss substantial numbers in eligibility under 2.6.3, and then later in 2.9, discussing the pro bono allocation, they refer back to that guideline.
Okay, well, so we haven't applied that then.
Yeah,
that we haven't connected them in our application process.
Gotcha.
But I like I said, I don't recall there ever being an instance where a program qualified for just that prong, but not one of the other ones, because the other ones are so comprehensive.
Right, that makes sense.
But then the question is, do we need to do something about it, given the interrelationship, I guess, is what I'm hearing Brady say about those two? And even if somebody doesn't qualify now, I mean, you just like, if we're looking at this, we should look at, make sure that whatever the fix is doesn't cause a problem at some future point with the interrelationship between those two sections that Brady mentioned.
So what do you suggest, Brady? Because then we can't, we're still going to be defining it. We have to absorb it into like one whole test. We're moving it from the threshold, but we still have to abide by the statute, right? In that language of substantial. But if it gets absorbed into the principal means test, would that be satisfactory? Or,
well, I mean, so the way that it is now, you could leave the existing substantial means test for programs that would want to establish eligibility that way, although it sounds like nobody does. And then as far as the pro bono allocation, you don't refer back to that. You just focus on principal means.
So it looked like Eric had a comment. Did you want to, he was on the working group. You're okay? Okay. So got it. So the way it's set up now, just to make sure I understand the guidelines, this threshold test sort of exists separate from the pro bono allocation. The pro bono allocation refers back to it. And so if we could separate it at that level, leave it for any other definitions of substantial numbers, but not for pro bono allocation. Is that what you're saying we could do?
Well, I'm saying conceptually, it doesn't, and this seems to be the simplest way of conceptualizing the argument for getting rid of the threshold test for the pro bono allocation. By establishing your principal means, you are by definition establishing a substantial number, right?
Okay. Yeah.
So I guess I'm agreeing that you don't, in the pro bono allocation, you don't need to go through the same hoops. You don't need to go through those hoops of substantial numbers if we're going to just put you through the principal means test. But we don't necessarily need to get rid of the guidance that exists in the instance that a applicant wanted to establish eligibility using substantial numbers. Because you could conceive of a situation where an applicant would want to establish eligibility using substantial numbers, but might not meet the principal means.
Got it. Corey, your hand is raised. What's up?
I'm not. I guess we could have moved on from it, but I just want to make sure that this gets enough thought. And we may, I'm just making the point, we may not be able to completely be clear on it in the midst of this meeting, just because if there's a risk that we're going to essentially define this term differently for two purposes, that's not really gonna work. So and maybe we don't have to do that, because if we're collapsing the tests, then maybe we don't need a definition here. And I think that, Brady, that's what you're suggesting, but just that we need to be careful about it. And if it requires further analysis, then we should maybe give it that analysis.
Great. Catherine, you have your hand raised?
I'm probably agreeing with Corey, although I must say I'm getting a little confused about where we are, but to say we're going to leave the substantial number or substantial means at its current level, I don't know that I think that doesn't really address the problems we've just identified in particularly rural counties. So if you were a small program in a rural county and you wanted to meet that eligibility criteria, but now you have to have whatever it is under the current test, 5%, et cetera, you're not going to be able to do that. So anyway, I think we can move on, but just once we figure out what tests we're using in the pro bono allocation, figure
Well,
out if that's.
I mean, it might be a non-issue practically, and it just goes to how we end up drafting these, because to be clear, the only way that a grantee would need to use that substantial numbers to establish eligibility as a grantee is if they don't get LSC funds, if they don't get Older Americans Act funds, and if they can't establish that they provide services to a special group, which includes youth, immigrants. There's a whole long list. And I would think that most of our programs, if not all, could establish that they serve some specialized groups.
Got it. So essentially, when we're talking about qualifying as a QLSP, there are multiple ways to do it. One of which is the substantial numbers approach. But when we're talking about pro bono allocation, you have to meet substantial numbers under the current test before you can go anywhere else. So if we switched it and said, by doing principal means, you therefore meet substantial numbers for purposes of pro bono allocation, you're essentially giving sort of more options. But I do take Corey's point, which is if substantial numbers is in two parts of the statute, and we're sort of saying in one, it means one thing, and in the other, I mean, we're already kind of doing that now, right? Because if QLSPs can qualify multiple ways with substantial numbers, I don't know, I guess the statute, yeah, never mind. The statute gives you multiple ways to do it, right?
Yeah, but what I'm saying, and also is in that part of the application, how it plays out is that we haven't tied it, even though I'm hearing from Brady, because it does talk about in the guidelines. Practically speaking, the staff hasn't tied it. Like when we review that question and they check, they have how it's designed is the applicant has, they can check whether, they're LSC funded or they receive Older Americans Act, or they provide substantial numbers of pro bono attorneys. When they check that, we don't then go to the chart like we do with the pro bono allocation. Even though I'm hearing Brady saying that there is guidance for that, we haven't actually done that then.
Okay.
In practice. So
if we adopt the working group's recommendation, do we understand clearly what we're lining out of the guidelines and what we're leaving in the guidelines?
Okay, so that's also another not technicality, but we've been told more recently, and we did, Brady and I brought this up, I think two rules committee meeting ago, that we've been told that by executive staff that we have to phase out the guidelines and bring everything up to the state bar rules. So once we have the working guidelines, Brady's actually going to be the one that's going to help us move it into what part of the state bar rules is going to look like. Because essentially what our guidelines have been are underground regulations. They are policy tucked into guidelines. So because it's policy, we have to move it up to a state.
And they're not formal regulations at this point?
Well, I mean, they've been through the Appendix I, the Board of Trustees recognize them as the operating guideline, as the operating regulations, and to change the guidelines would require Board of Trustees approval. But the desire for consistency is to, and so for ease of use, frankly, so we don't need to go looking at statute, state bar rules, and guidelines, is to bring everything up into one set of regulations, which is the state bar rules.
Got it. So can we start from a clean slate, I guess is the question, or are we going to be
It's really
amending
difficult,
things?
Erica,
Yeah.
because Brady and I have been talking about this for months. We can't approve the whole package, because look how we struggle with each issue, and it's taking months. So if we're going to wait to the whole package, I don't know when that's going to be completed. So we have to do it piecemeal. And so it's going to be a little bit clunky, because the feel of our guidelines and how it's written doesn't really match up with how the state bar rules are written now and where it gets inserted. And that's the piece that Brady's going to have to help us figure out.
Okay.
And those expungement and QEs might be the first to go.
Yeah.
Got it. Okay. Well, you've given us some stuff to chew on. Do we want to, is there more conversation we want to have on this issue, or should we?
So I have one more thought, because I do sense some uncomfortableness, because it is in another part of the statute. So if we can finalize, I guess, even in concept, what the recommendation could be, Brady and Erica and Judy and I and Elizabeth will take a closer look. We'll have another bite of it, obviously, at the commission level, so that we don't have to we can bring it back to the rules committee again, but we've been bringing everything back to the rules committee, and we haven't moved on any issues. So my recommendation would be, let us take a look. We have to hash it out with the commission anyways. And at that point, maybe we talk about it, whether Brady's initial right now, his strategy would be amenable to entire commission, just to move things along.
I see. So your suggestion is that we basically, at the end of this, adopt something that says, we want to try to get rid of the threshold test, and we want you guys to figure out how to do that. And then we'll discuss it at the commission, whether that's feasible.
That would be my suggestion.
Consistent with regulatory and statutory requirements. Okay.
I think that makes a lot of sense.
Yeah. Okay. Why don't we continue on, and then we can collapse all this together at the end. Thank you.
It's just very difficult because everything is tied together. And I think that was why our instinct on the outset was just to wait to do all the recommendations and then package it into a whole new set of rules for the State Bar Board of Trustees. But I don't think
we'll be dead before that happens, right? Like, I feel like everyone wants to, like, I don't know, every federal agency is trying to, they all want to work together on their packages, and then nothing comes out. Anyway. Yeah, no, we should move piecemeal. That's fine. Okay.
Dawn, I'm thinking it might be helpful to jump ahead to leave these definitions for our third area of discussion and go ahead to the principal means tests and those modifications.
Either way, but I know some of the sticking points are in the definitions. So I defer to you. I might stick to the principal means and then do the definition.
As is though.
Okay.
Yeah.
And we can just do overview and can save discussion and decisions. So actually, again, just a quick overview and summary of if you pass substantial numbers, here are the principal means tests A, B, and C. With A and B being comparisons of staff versus volunteer, and then test C being the narrative example. Now, in this scenario, these are not mutually exclusive. We can adopt any, all, or none, but things we're going to discuss are defining staff attorneys to include legal fellows, whether we want to revise test B to include both paralegal hours and non-attorney volunteer hours, clarifying when law students are pro bono volunteers, and whether we can count staff hours that are spent on pro bono activities as pro bono hours versus staff hours. So jumping into defining staff attorneys as legal fellows, that's A and B compare the attorney hours against staff attorney hours, but they don't define who's included under staff attorneys. Fellows typically are employees for 1 to 2 years at the organization, although that salary may be paid by a third party, most often a sponsoring law firm. And the fellows perform duties similar to entry-level staff attorneys. Our current office practice tells grantees to list fellows as staff attorneys. The feedback from the legal aid community is that they are not in support of this. They feel that there is a disincentive from seeking support from fellows because it'll skew the balance of the numbers in the pro bono allocation test. The fellows' salaries are due to third-party support, and as newer law grads, these fellows are not performing the same type of work as staff attorneys. The recommendation from the working group is they're trying to exclude, but they would like further discussion with the committee. And it may be possible to count fellows as neither staff nor pro bono.
Yeah, we would like a more discussion on this topic because the working group kind of struggled with this. I think the staff recommendation, we struggled with it. I want to ask is that it be consistent. So if they, if they can count it, they can't kind of game the system. So they can't say count in some instances and not in instances. So we have to treat them kind of consistently, the legal fellows, whether we count it all or don't count them at all.
Can I weigh in on this one? Normally I agree completely with the legal aid community. I completely disagree here. Law fellows are lawyers. They're performing legal functions. The growth of law fellows is something that's happened in recent years, and it's as a result of the fact that there is additional funds out there that have been made available, often by law schools, sometime by other pro bono organizations. But they're not, part of the requirement of those fellowships is that they perform legal work. They're not meant to be substitute for anything other than legal work going forward. So I don't buy the argument that this will dissuade the legal services groups and skew the pro bono allocation test. Legal services groups have every incentive to have fellows because they're usually paid by somebody else. And so they're a total net plus for them. I just don't think it's very logical to say somehow we should exclude these. The next thing you argue is that certain kinds of attorneys should be excluded. Doesn't make much sense to me.
And Judge Salome, I think was kind of the staff's leaning because the new provisional licensee lawyer awards, like we've seen some kind of organizations call them as fellows, but they're attorneys with the fellows too. Technically, sometimes they're licensed and they're called a fellow. So this is where we struggled. And I think you kind of articulate our leaning, but we don't have a strong.
And I think, and this might be theoretical. Oh, hello. Can you hear me?
Yeah.
But you could imagine, say a smaller group that a smaller legal aid agency, if they had a bunch of fellows doing a bunch of, if they had as many fellows as they had attorneys, and they weren't counting those in trying to determine whether pro bono was their principal means, you could have a situation where we found that if we excluded them, we found that pro bono was their principal means, even though when you combine the work of the actual, individuals who are being paid for their work, the fellows and the staff attorneys, it outnumbers the pro bono, and I think that would defeat the purpose of the pro bono allocation.
Yeah, I think the other thing is in consideration of whether to put a fellow out there, the usual entries. And I'm actually on a fellowship board for Hastings, the Abisko Fellowship. And so I'm reasonably familiar how this process is done. We regularly look at other fellowship programs to make sure we're not duplicating what they're doing. We look at the resources and the size of the entity and their capacity to support the fellows and the capacity to turn the fellows into long-term positions. So it's unlikely in most cases that you're going to have more than one fellow in a small organization out there. Larger organizations, like for example, Legal Aid at Work, they regularly have a slew of fellows because they can support them. They have the resources to do it, and they have relationships with various organizations. If you exclude those, you actually are giving a net advantage to, again, an urban area that has the ability to have a lot of fellows.
Corey, you had your hand raised. Did you want to make a comment?
It was pretty similar. I just said if someone's an attorney and they're doing the same
work that another attorney would be doing, except that they are only on likely there for 2 years. There's limited funding for them. I just don't see how that's different. And it may be that a first year attorney is not super useful, but that's true whether they're a fellow or whether they're a permanent hire. So nothing against first year attorney. Everyone gets to be one.
Jim, you have your hand raised?
There's 3 people with their hands raised. Heidi Slater, Selena, and James Meeker.
Okay, I see Jim, so why don't we go with him first, because on the committee, and then we'll get Selena and I can't remember who the third one is. Jim, go ahead.
All right, I agree that I think the fellows ought to be counted for all the reasons mentioned, but since the same time that we're meeting, I think the California Paraprofessional Program is meeting. I mean, do we need to also consider the issue that if we're going to have limited licensed technicians, shouldn't they also be counted if they're employed by the organization?
That's another part of the working group, I think, is broadening the definition of staff attorneys and pro bono more generally. So that is an issue that we're gonna, I think, get to.
Okay.
So yeah. Selena, you had a comment?
Actually, I'll let Heidi go before me because I think I was
Okay.
because Heidi has a point, and I'll talk after her to fill in the gaps.
Got it. Heidi?
Hi. The one point I would just like to make is that we are a small organization that every year is just on the edge of whether or not we qualify as a pro bono organization. And having to count fellows as staff members does harm us. And it does make a Sophie's choice for us. So we actually don't choose fellows very often when we have the opportunity, because it would eliminate our pro bono eligibility. And I strongly believe that these fellows should be carbon neutral, as I call it, because they're only there because a third party pays for them. We would not have them on staff otherwise. And so not forcing us to count them, which we have historically done, does serve as a disincentive, and it penalizes agencies such as ours, the size we are, in this statute or in this rules, how it's applied. And so I would strongly caution that there are, unintended consequences here that do harm organizations by forcing us to count them. And so we do really have to make hard choices about whether or not we take on fellows. And often the fellows that we do take on are doing novelty sort of types of law, not our regular types of law. So it isn't, they're building a program or, serving an underserved population. And sometimes when you're building a new program, it's very hard to add an additional 2,000 volunteer hours to that to offset the addition of that fellow's hours.
Would that problem be less though if we got rid of the numeric test? Isn't that really what causes this to be a problem?
Well, maybe, but I think that, I don't know, I come from such a history of that numeric test is in my blood, so it's hard for me to imagine, but I do feel like it becomes this, this idea that I have to really justify, sort of why we, and in fact, our last pro bono allocate or approval process, we did have to justify because we did have a law fellow and we missed the numeric formula by about 700 hours or something, because of, we had to count that law fellow. And so I feel like they just should be carbon neutral. They benefit the indigent community because they add a body, but they also take, it's not something that we have to provide a resource for other than medical insurance in most instances and payroll taxes, so it's a very cheap way for us to get that additional resources, and to be penalized because we take it. Yeah, I think is not really sort of the intent, I guess. So if you eliminate the numeric formula, although I only see you wanting to eliminate test 2, you're still using the test 1 or test A rather, and that still is going to stand as far as my understanding of how your recommendations are shaping up.
Yeah, that's correct. We would still, the recommendations at least are, we would get rid of the substantial numbers threshold test, but that doesn't have the balancing between staff and pro bono, and that test would still remain, but you'd still have test C, which would, I guess, be test B. Anyway, Selena, did you wanted to make your comments, and then Catherine, I'll get to turn to you.
I think the only thing to add to what Heidi said is that with fellows, typically when you hire them, they are not yet attorneys. Just because of the calendar of the bar exam and the the normal calendar of the bar exam and bar results. And so it's just a snapshot in time where you're counting, you perhaps may be counting someone as a staff attorney who is not yet able, as Heidi said, to be able to kind of balance the numbers of having additional pro bono hours. I think for other purposes of IALTA, the aggregate counting that we do, we want to count them as staff attorneys to talk about them as the kind of attorneys in the office. But for the purposes of pro bono allocation, it's just a different use of the same number, I would say. You're not going to bring on a fellow who can support the kind of pro bono attorney burden that a staff attorney of several years out could.
Thanks, Selena. Catherine?
So I guess partially it was what Selena said, which is there a distinction between attorney fellow and non-attorney fellows when you count them? So I probably agree that if they're an attorney, an attorney is an attorney and you should count them as attorneys. But there are, I mean, my former organization, we actually created fellowships that we funded to get recent law school grads into our program, with the understanding that those initial fellowships were limited for 2 years. And in reporting to the bar, if they did not pass the bar exam, then they weren't counted as lawyers. And if they did, they were counted as lawyers. And, if you're not a lawyer, there's certain things that you can't do. So is there a distinction between are they admitted or aren't they admitted, that I think might be worthy of some consideration?
So I was just gonna speak to that a little bit, and I believe, and maybe Dan and Elizabeth can clarify, I don't believe there's a distinction, but I was just reflecting back on my own career. I was 3 fellowships, and the first one where I hadn't passed the bar exam yet, but the last 2 I was an attorney and a fellowship position for 3 years. So yeah. I don't know if that's quite accurate, Selena. But how do I can't recall, Elizabeth, Dan, how we apply it. I think there's a distinction, right?
I don't think there's a distinction either, because they are, even if they're not licensed, typically fellows are, doing work that like a first year staff attorney typically would do, except for, the representation part. And so I know, my experience in the field before joining the state bar is that that's how a lot of legal aid organizations treated their fellows. And they didn't treat them as non-attorneys necessarily. They even if they were still waiting for bar exam results, they, a lot of times they were, I can't remember what the special certification is where you can appear in court with like if you're a law student, that sometimes they had that kind of certification. And so I don't know if we can make that distinction here.
But that only applied, at least unless the rule was changed, until you took the bar exam.
Oh, okay.
There have been instances where organizations have sort of reclassified people mid-year because their fellowship switched from what we would call a paralegal fellowship, where they didn't have licensure yet, to being an attorney fellow. I can't say this is a formal policy. I don't think that this is an issue that's ever received this much attention. But in terms of our general patterns of practice, we would look to when the license was issued. That was traditionally how we did it in this office.
Jim and then Brady.
Yeah, I was just thinking, couldn't this issue be handled under test C, where the program could describe, let's see, we have fellows that are not admitted to practice yet. That's why we're not going to count those hours. Or we have a fellow that's licensed, but they've been assigned to a special project that doesn't represent clients, say like developing the website or whatever. But test C would allow a program to exclude certain fellows for specified reasons.
That's a good point. Yeah. Brady, what was your point?
So to clarify, are these fellows directly paid by third parties, or
It's a combination, Brady. Sometimes they are, sometimes they're like in-house fellows, like there's a fellowship that the organization has. Sometimes it's by the law school. Sometimes it's like another funder, like Equal Justice Works AmeriCorps or Skadden Fellowship. I mean, it comes in all kind of.
And sometimes like there's a limit. Equal Justice Work says you can't pay, you have to pay the rate that you pay people in similar positions, but we're only giving you X amount towards that. And so if your salary scale is higher than that, then it's a combination of money you get from the fellowship and money that you're putting into it. So there's no one way.
Because I'm just trying to think about this and trying to figure out whether most of these, whether this work is showing up in the qualified expenditures. Because the way that I think of the pro bono allocation is that we are recognizing that that is legal work that's being done that is not reflected in qualified expenditures. And so therefore, to fund and encourage that legal work, we give the pro bono allocation.
Why wouldn't it be shown?
Yeah, I didn't follow that last part, Brady.
Because pro bono attorneys in private practice are free. So this is legal work.
I thought you meant the fellows weren't counting in qualified expenditures.
No. The pro bono attorneys who are not reflected in QEs, but so it's sort of a multiplier, and the statute therefore recognizes that and provides that additional funding for organizations where that's their principal means.
So is your point, I think just to raise, but so if a legal fellow is entirely funded or primarily funded by a third party, let's say their salary is funded by a third party, and then QLSP handles just health insurance, only most of their salary is not going to be counted in qualified expenditures, right? It would be like a pro bono attorney. They'd be getting work without the qualified expenditures calculation.
Yeah. I mean, I'm just trying to think this through. I recognize Heidi's, as an individual program, the choice that it forces. But on the flip side, the whole point is we're trying to encourage and reward because they're going to have lower qualified expenditures. Those organizations that truly have a focus and their principal means is doing pro bono. Different grantees have different business models, and there's a decision that's been made that because you're not going to get funds for your pro bono work unless we give you these special funds, that a certain business model is entitled to these funds and others aren't, because most of their work, and it sounds like in some cases maybe not the fellowships fully, are going to be funded through the QE calculation.
So I'll just make a comment, because I think on the working group committee, I was probably the one who was advocating the legal fellows should not be counted as staff attorneys. Like most, I was probably of the three, like one of the ones who was most pushing for it. So I'll just provide my perspective on it, such as it is. And I guess to me, it depends in part on like where the funding is coming from, but especially if it's coming from third parties and these legal fellows are temporary. To me, it is not, I advocated for them to be neutral, which was they're not pro bono attorneys. They don't get to count for that, but they also don't have to count against the organization as staff attorneys on the basis that they don't end up working with the organization permanently. They're there in a transitional type of position, and they're funded generally from outside. And so in some ways it's, you're incentivizing these attorneys to essentially work pro bono full time, right? For the particular organization, because they're basically getting, not entirely free, but very discounted work, and they're taking on the burden of training, which often for big law firms, right? The reason that they encourage their attorneys to do pro bono is to do training at the beginning. So that was why I thought they should be neutral. Like they shouldn't count as pro bono because they are getting paid. They do provide, I think, more than just the pro bono work that pro bono attorneys do, but they also shouldn't necessarily count against the organization because it's this temporary transitional type of position that might be specialized. Having said that, I think Jim's point that maybe this is all better to be addressed under test C than to actually change the staff attorney definition, might be the way to address the exceptions, or the different unique circumstances, rather than trying to define what, if you are funded this much versus that much, and if you do special projects or not, like trying to create those bright lines may not be that helpful. But this was why I had sort of advocated for us not counting them as staff attorneys.
Selena has her hand raised.
Okay, Selena.
I'm just speaking in agreement with Erica on this issue about dealing with it in test C, because I think that we would all agree that fellows should count as attorneys if they are barred and if they are attorneys, but just the wrinkle is whether or not they should count as attorneys for the purposes of the pro bono allocation. And I think test C would help if an organization like Heidi's was kind of on the cusp and they had a fellow one year, in the prior year they hadn't and it was fine. Now they have a fellow and they're on the border. I think that applying test C might be helpful for those circumstances where adding a fellow would kind of put the balance in a different area, even though the organization still is a pro bono organization.
Yeah. Any other comments or people's hands raised that I am not seeing? Okay, well, it sounds like there sort of is a consensus that we should not explicitly exclude legal fellows from the staff attorney definition. And it sounds like maybe that there's a consensus that we should include them, but potentially with some guidance in the test C that there might be exceptions where that, like maybe we could be more explicit in test C about how the legal fellows are funded or what's going on. Is that kind of where people are falling? Okay.
That's what I'm hearing too, Erica, so.
Yeah, okay, that's great. Okay, so as hopefully someone's like taking notes of where we're taking temperature on this, I'll try to as well. Great. Why don't we move on to the next one? And my thought was after the next one, it'll be about noonish, and then we can take a break for maybe 10 or 15 minutes so people can use the restroom and grab a little food.
Yeah, just along those lines, Erica, with the timing, with this second bucket, we still have 3 options. And then with the principal means tests, we also have 4 options. So
okay.
We are
well,
not
we just
quite
need to
yet
go
halfway
right.
through.
Okay, well, I still want to take a break after we've been going about 2 hours because, yeah.
I agree.
I don't know, I'm gonna have to use the restroom soon, so I assume other people might as well. Anyway, go ahead, Judy.
Okay, so the second definition we're looking at is whether to revise test B to include both paralegal and other non-attorney role volunteer hours. Because in the last 30 years, since the IOLTA statute, the delivery of legal services has changed somewhat dramatically. And holistic services now use interpreters, legal assistants, social workers, undergrads, bilingual intake volunteers, et cetera. And these non-attorney roles help the organizations to increase the number of clients that they actually serve, and also to provide culturally competent services. Our current office practice is to allow counting some of these roles when they're related to the legal outcome. And like paralegals, these volunteers are supervised by attorneys and are trained in the QLSP's individual services and legal subject matters. The community was in support of this proposal. They felt it reflects the full scope of service delivery and how service has evolved. Also, rural programs rely extensively on non-attorney volunteers because there are no large law firms to draw upon. And non-attorney volunteers can also contribute to diversity in the profession. One of the comments in the pro bono allocation survey said that we have coming in our undergrad students that were brought on, my understanding is as bilingual interpreters and intake volunteers. But once they had been working with the program, though they hadn't envisioned a legal career for themselves, those wheels started turning. So in that regard as well, kind of a pipeline advantage. And the recommendation from the working group is to expand test B to include both paralegals and these non-attorney roles where their service is directly related to legal outcome.
Great. The one thing I would just want to note maybe here is there is also a recommendation later about whether to even keep test B. So just as a preview, this may become moot.
We may want to hold off on this discussion entirely and address those two, discuss those two together.
Yeah, well, I do see that Catherine's hand is raised, so I do want to make sure we address her comment.
So I think my question is that if you do that, so I agree with sort of the analysis that lots of programs rely on non-attorneys to both internal and external, but are you then, so on the attorney side, there's this comparison of who works for you and the pro bono hours, but that's for that you're only counting staff attorneys. So are you then doing something similar where you're going to count the people in your program as paralegals and it has to exceed that? I mean, it's sort of like there's two sides to this equation, right? What do you count as pro bono and what are you counting as your staff hours? And I think there's different outcomes if you fold an additional group into the equation of pro bono, but you're excluding similar people in the organization. So I'm just trying to understand which way the proposal is.
Yeah, these roles would need to be counted in relation to both staff and volunteer hours in order to be fair.
But staff non-attorney hours. So if you're counting a okay, thank you.
Yeah, so it would be equal. So if we expanded the paralegal, it would be for both staff and for pro bono.
Thank you very much.
Yeah. Any other comments or questions on this one? Otherwise, I think we should wait and then talk about this with our proposal about getting rid of test B generally, because if we decide to get rid of test B or recommend that, this is kind of moot at that point. So
agreed. Okay.
I have one question though.
Oh, Eric.
We deal with law firm Summer Associates.
What's that?
Law firm Summer Associates.
You mean in this part?
Yeah, well, my understanding is that firms often
they love
associates for pro bono projects, and so are they?
I just want to pay.
Are they? I mean, they should be. It seems to me they should be. Their hours should be counted as volunteer hours, but are they?
I believe they are. I'm trying to think of what section they are.
Are they in the law student section?
Yeah, maybe the law student section. I was just about to say that. Erica, do you remember off the top of your head? I think it is a law school section.
Yeah, I think in the application itself, there is more of a breakdown in terms of categories. And so organizations can actually report law student hours themselves. So.
Even though they're not attorneys yet, they're counted as pro bono attorney hours?
No.
No, they're not counted as attorney hours.
No, they're just counted as law student hours. But not for purposes of the allocation.
No, yeah.
Just for info gathering.
But what I imagine is if you want we would count them as non-attorney volunteer hours.
I mean, unless we defined it more specifically, but I thought we had suggested being more broad about it being paralegal and non-attorney directly related to legal outcome. It would seem to me that under that broader definition, a summer associate would count as a pro bono.
Yeah, I agree.
Yeah. But again, that all depends on if we keep test B.
Right.
Yeah, right. Any other comments or questions?
So do we have a proposed wording on how to include that in test B, or are you just saying we're going to get rid of test B?
Well, that's one of the discussion items coming up within the third bucket.
Yeah. So all I'm suggesting is we defer, and if we decide to keep test B, then we have this further conversation in the wording at that point. But if we decide to get rid of test B, we can sort of bypass this conversation at that point. That's all I'm suggesting.
Exactly. Okay. So then our third definition is clarifying when law students are pro bono volunteers. And here I want to differentiate law students from legal fellows. These law students are at the organization for either a semester or a summer sometimes, whereas legal fellows are usually full-time junior staff members for a 2-year period. Now, some of these law students may receive a stipend from a third party, or they may receive credit. And there's no definition of compensation as it relates to pro bono work in this context. So if we're looking at whether they're compensated or not, we don't have any guidance. Students are not compensated by the QLSP and do not receive benefits from the QLSP. The stipend is not a living wage, and these positions are training opportunities. And the students are encouraged to pursue legal aid employment or become pro bono attorneys themselves after they graduate from law school. So again, bringing in some pipeline considerations.
All right, I have an initial question on this, because maybe I misunderstood this when I was on the working group. Is the recommendation that we count them as pro bono attorneys?
No, pro bono volunteers. And under the non-attorney category.
Got it. Okay. So only if we kept test B would this matter.
Correct.
Right.
Okay, perfect. I just had a little moment of like, that's what I understood, but I wanted to make sure.
But it might also be a factor in test C though.
Yeah.
Right?
Yeah, yes.
Mhm.
Test C is like, that's just what we're gonna end up with.
Yes.
It's a totally discretionary thing.
Mhm.
No, I'm not suggesting that. Sorry, Judy, go ahead.
No, that's fine. So the legal community was in support of this. They feel it's consistent with how their own organizations view their law student volunteers. And a small stipend or academic credit is really secondary to the learning experience. They're there to get hands-on skills. And the recommendation from the working group was to include law students as pro bono volunteers under Test B, specifically including those, even though they may receive a third party or a nominal stipend. So we can lump this together with the Test B discussion if we want to move ahead. Our final definition is whether we can include staff hours dedicated to pro bono activities as pro bono hours. Now, the current office practice is to treat all staff hours the same. There is the possibility of separating out hours spent supporting pro bono programs from the typical non-pro bono responsibilities. But the increased hours spent training and supporting pro bono may make the organizations ineligible for test A and B. Again, kind of the seesaw. As staff hours go up, the likelihood of getting the allocation goes down. Now, additional tracking would lead to complexity, but it would be a more accurate measure of the dedication to the pro bono program by the organization. But a change in this regard would require significant change to the guidelines. The legal aid community was in support, although there was no specific feedback on this particular proposal. Their general feedback is that increasing staff may impact pro bono allocation and that a reluctance to hire would hinder service expansion and reduce access to justice. The recommendation from the working group was undecided. Adopting such a change would require significant revision to the guidelines and would run against our goal of making the test simpler. This would actually make it more complex. And finally, Test C can be used to explain any anomalies.
Does anyone have any comments on this proposal? So Jim, I think you're on mute.
Yeah, sorry about that. I got a question to staff. Currently, how many programs qualify under Test B? I mean, seems like a lot of these things has to do with implications and problems with Test B. And does this rarely occur because few programs qualify under Test B, or is Test B a large category?
Judy, do you have that number off the top of your head?
Yeah, Test B is not a large category, and this is not an official metric, but I have a list here with applications. Now, I don't know how many of these were ultimately approved as pro bono allocations. There was only one organization that applied under Test B.
Out of how many?
Yeah, one out of 30,
Okay.
30 projects, approximately 22 or so individual QLSPs. All of the other organizations who applied under Test B also qualified under Test A.
But isn't
So
this
again,
relevant?
Isn't this relevant to both Test A and Test B? Like, for example,
This
if
one
it,
is.
yeah,
It is.
yeah. I mean, I think the implication of Jim's comment was that it would only be relevant. Like if an organization hires a pro bono coordinator, let's say, an attorney whose sole mission in life is to build a pro bono program, right? So wouldn't that be the poster child for the kind of staff hours that you would take out of the equation if we went down this road? Do I understand this correctly? I think that's what we're talking about.
Yes, but there's also like, there's like the coordinators or and just generally like staff attorneys, I will say, is being a pro bono attorney from like big law, like they often spend a lot of time with like junior law firm associates, like teaching them how to do this stuff, even one-on-one. And those hours would all be counted as, I believe now, as staff hours, even though they're not, it's not like they're doing direct, they're actually supporting pro bono, not doing direct legal services, you know, in comparison. So, but that could be a Test C issue, right? Like a lot of this could be drawn in Test C. That's, I don't know whether it's worth making it more complex.
Yeah, I agree.
Yeah, but that, I saw that as an issue is, you know, there's a lot of experienced pro bono attorneys, but I know as a junior attorney, I did a lot of pro bono to get into court and stuff. Other comments or questions on this issue? Do people or members of the committee think we should redefine it? Should we keep it to Test C?
It's Catherine. I just feel like this adds a level of complexity, and I feel like we're on a path to try and make this more simple, and interjecting something like this where you're trying to track hours differently, just, I don't know, it seems complicated to me, both at a program level for bar staff, particularly if you're going to go out and do a monitoring visit. I mean, it's just, anyway, I think it's complicated. I don't think it really helps that much.
It's complicated and it seems to be stretching a little bit in a few places too, in order to get the desired result.
Yeah, I mean, it's a good point. It adds a gray area to a bright line, right? Like what is staff attorney that's pro bono versus not? Is it a training? Is it when you talk to the, you know, definitely an issue. Okay.
When if you have a pro bono lawyer and you're both sitting there and you as the staff attorney are interviewing the client, but the pro bono attorney is sitting there because they're learning something about the way you do this.
Right.
Counted or not counted because you're actually doing the work and somebody's watching you. I really, just as I put my like former director hat on, like how would you keep track of that and have a system that allowed you to do it in a consistent way among your staff? So.
Right.
Selena has her hand raised.
Go ahead, Selena.
Trying to remember what I was going to say. I think, oh, I remember what it was. The only question I had, I think that the community was in support of this because they thought of the staff hours that was really supporting via training and mentorship and support of the pro bono attorneys was very different from the staff hours providing legal services to clients. But that said, if Test C can deal with some of the wiggle room areas, especially the example in the memo of adding additional training by staff for pro bono attorneys could put you over the limit in the opposite way. I think the ability to use Test C might fix that problem.
Elizabeth?
I was just going to add that I know for LSC funded organizations, they need to segregate their private attorney involvement hours. And those hours are what Selena just talked about. For staff attorneys, what's counted is like the time they spend providing a training, the time they spend mentoring or providing technical assistance, and that kind of support for pro bono attorneys. So, I mean, if we wanted to have like a very clear definition, we might want to look at LSC. But if folks think that Test C is the better option to kind of put that information, I think that's a good idea. But I do think we need some parameters, because otherwise it is totally every new submission before the commission will be like a brand new inquiry, and there won't be any parameters. So I just wanted to add that.
All right, so it sounds like at least many of the organizations may already be doing a form of this tracking that we're considering. Corey, you have your hand raised?
Yeah, I'm sorry, but I had I came back into this conversation after having to take a brief urgent call, and so I'm not quite clear. Are we discussing the other proposals also at this point about, for instance, law students as pro bono, or no? We're past that.
No, we've moved past those two. We were going to discuss those in terms of whether we keep Test B at all. But this
Okay,
one,
that's what I presumed. I just wanted to double check. Okay.
Yeah. But because this one affects Test A and Test B, we sort of had more conversation about it. And potentially Test C, because we have proposals about adding more guidance to Test C.
Right. Okay, that's what I thought. Just wanted to be sure. Thank you.
Yeah, sure. Any other thoughts or comments on this? It sounds like the committee is, at this point at least, not in a position to recommend that we change at least at the Test A or Test B level, like how we distinguish pro bono hours under staff attorney hours. We want to keep that bright line, but then potentially under Test C, we could, provide some parameters there. Is that where the committee seems to be sitting? Does anyone object to that as my temperature check? Okay, hearing nothing. Okay, why don't we keep going? Or do you want to take a break? Is this a good time to take a break?
It's the perfect time, and I was going to suggest, because we're moving on to bucket 3. This is
this is a big one.
Ideal opportunity.
Yeah. Okay. So why don't we is 15 minutes enough, or do people need more? Because I want to make sure we still have time to get through the rest of our agenda.
The 12:15, Erica?
Yeah. Why don't we come back at 12:15? Okay. Thank you, everyone. And so I guess we should try to get back into it, try and get through the rest of our agenda.
Should I do roll call?
Yeah,
Roll call vote? Okay.
Yeah. Dawn, how much, what should be our estimated end time for this portion of the agenda?
If we could wrap this up at about 1 o'clock, that would enable Dan's issue is pretty straightforward. I don't think he will need maybe more than a half an hour. And then he has some preview issues, but if we don't get to the preview issues, I think that's fine. So, 1:15.
So I can have in my mind how.
So you have about 45 minutes an hour
to jam through the slides.
Yes. So Erica, just whenever you're ready, then I can do the roll call vote.
And there's also a chat from Selena about she has some update or something.
Oh, okay.
Let's do the roll call vote first, just to make sure we're all back, and then we can go.
Okay, great. Amin, Luis? Luis, are you back yet?
I'm here.
Okay, great.
Still eating my lunch.
Okay, eat away. Catherine?
Here.
Erica?
Here.
Corey? Corey, are you back? Jim? Jim, are you there?
Yes, yes.
Okay, great. Judge Sellerman? Judge Sellerman?
He, in the chat at some point had noted that he might have to leave again for a call, so.
Okay, but I see him. He's just, oh, he's probably not, he's just not back. So we're missing Corey and Judge Sellerman, Erica.
Should we wait or?
I think they were both shuffling other obligations, so perhaps we begin.
Okay, why don't we continue with the discussion and then we can.
And I
figure
believe
out-
Selena had a comment, right?
Yes, so Selena, do you want to discuss first?
Oh, sure. It's just a quick update. I reached out to Assembly Judiciary Committee staff to ask about the timing for suggested amendments for the change to the 200%. And since Dwan and Brady said that they were going to work on language, I just wanted to report back that the answer is not now because they're buried in a lot of hearings.
Okay.
So they said anytime after May 4th. So that week would be a great week to have something ready, but definitely don't worry about getting it together in the next week.
Okay. Well, we'll just, whenever we can, we'll get you something, Selena, and then you can be ready when you think is appropriate.
Perfect. Yeah, I just wanted to let you know it's not nothing
Okay.
to rush on.
Okay, great. Thank you so much.
Awesome. Okay, so I guess we'll turn it back over to you, Judy, to start talking about our next.
We'll
big
jump
bucket.
into our various proposals for alternate principal means tests. And these are not mutually exclusive. Again, any, all, or none we can be considering. We're going to look at whether we could have a principal means test similar to test A, but based on the number of clients served. Whether we should eliminate the numeric test involving the combination of attorney and non-attorney hours, that's test B, and whether we should add specific elements of a strong pro bono program as factors for test C. So here I've kind of cut and paste the different tests because they can get a little jumbled in our minds. So test A is just the straightforward comparing attorney hours, pro bono versus staff. And this test considers only pro bono hours, not clients that are served by pro bono. So for example, you can have a 3-hour workshop that serves 50 clients or 3 hours of individual client. In one example, 50 people served, the other 1 person served. So if an organization's pro bono attorneys serve thousands of clients versus staff serving hundreds, that argument can be made that pro bono is the principal means by which the organizations delivers legal services, but a system like this would be really difficult to implement. Primarily, would family members be counted as a group or individually? And even that would not be consistent. It would be based on the type of case. And then there are significant differences in the depth of services that are provided in, these scenarios. There was no feedback from the legal aid community regarding this option. The working group considered but does not recommend this approach.
Any questions or comments on this option? Hearing none and seeing no hands raised. Judy, why don't you go ahead to the next one?
Next, okay. So this would be possibly eliminating or modifying our test B. There's this, somewhat complex and difficult to understand 2-step calculation. It's not intuitive. Its goals are to ensure that a majority of hours are provided by volunteers versus staff, but also to make sure that volunteer services are calculated towards achieving legal outcomes. And as we discussed previously, it's unclear how many would qualify under test B, but not test A. Semi-relevant, but not 100% official counts. We only have 1 application in the last go around. However, it does allow organizations that rely on a lot of non-attorney volunteers to capture those contributions in a way that test A does not. There are two ways we could go about it, which is eliminating test B entirely and then possibly incorporating considerations under test C, or significantly revising the wording so that it's just total pro bono hours, attorney and non-attorney, versus total staff hours, attorney and non-attorney. So incorporating both those non-attorney volunteers while at the same time simplifying the formula. The community did not have feedback regarding this particular option, and the working group their recommendation is the first one, eliminating test B entirely. Reasoning test C is expansive enough to encompass organizations using various pro bono models that embrace a large number of the non-attorney volunteers that we had discussed.
Jim, you have your hand raised. Oh, you're on mute.
Sorry, a couple
No, no.
questions. One is, how many programs currently qualify under test C? And two, who applies test C? Is that staff, or is that the eligibility and budget committee, or is it a combination of the both?
I can answer the second part while Judy maybe finds how many for test C. So how it works in practice is if you pass test A or test B, which are the numerical tests, then staff like preemptively approves, and the commission still has to kind of approve final, like the award allocation, but that's just really a technicality. There's not a close review. If they apply under test C, all the test C narratives get elevated to eligibility and budget review committee for further review. And then the committee makes a determination, and then we package it for the commission. So the commission can technically pull it and disagree, but that's never happened. So it stops at really the commission, at the committee level. And then Judy, I don't know, do you have the number?
Again, this is not official. This is from a list I had handy from the last go around of applications. There appear to be 30 individual projects applied from about 21 organizations, because you can apply in more than one county. 14 of those were under test C, but not all of the 30 projects were approved. So roughly half of the total applications were submitted under test C.
So I'll just note, I was on the working group, and I'm comfortable with eliminating the threshold, but as we've discussed it, there is a part of me that finds having a second like bright line. The current test B is very confusing, but having a second bright line might actually be useful, just so this way, if we're going to consider that under test C, maybe we ought to just do a bright line under test B for not, and then just lump in non-attorney and attorney. But I'm curious to hear what other people's views are on it.
Heidi has her hand raised.
Who does? Sorry.
Heidi Slater.
Oh, Heidi, yeah, go ahead.
I come from an organization that is a test B organization for every single year that we've qualified. I think with the exception of maybe 3 years where we had to go under test C, we have been a test B organization. I have a PhD in test B, I feel like. I would strongly argue that there's no harm in leaving test B either as is, or I would actually advocate for test 2B as you guys have defined it here. That would make our lives so much easier. The problem with lumping us all under test D is it becomes a subjective test, and it also creates an additional burden for us to overcome every year, and it becomes this narrative argument, and there's no certainty as to what the bullseye is. Whereas test C is a very clear numbers, where I can monitor throughout the year how close we are or not and calibrate. If it's gone in its entirety, and we will never qualify under test A, that's just not our model. it creates a level of uncertainty and a really unclear, or, this unclear line as to where the finish line is. So I can't calibrate during the year. We can't, sort of make adjustments and, say, oh, it's working, it's not working, and test C becomes this just really subjective additional level of work that we will have to do every year to justify our program where, 17 out of 20 years, let's say, roughly speaking, all I've had to do is fill in numbers on a chart and be, and I've met the equation. So I would say there's no harm in leaving test B. There's, if you don't want to change it, fine. I would argue that you could just leave it as is. I would prefer, however, that you just, given all the conversation about how you want to count volunteers and this, that, and the other, you could certainly simplify test B to just make it all volunteer hours versus all staff hours. I think that there's a certain level of common sense in having that be an argument as opposed to making it this two-tiered sort of thing. So those are my comments on it.
Thanks. Those are very helpful, Heidi. Appreciate it.
Can I also just echo, I agree with Heidi in that, we want to give a lot of discretion to the committee and staff and programs, but having so many things subsumed in test C is going to make it very, very difficult for programs, staff, and the commission to review. So I agree with that point.
Thank you. Corey?
Yeah, thank you very much to the commenter, because I think it's a really good point that having a numerical test provides certainty. And it also helps reduce administrative burdens in terms of figuring out who's eligible. So maybe a simplified test B does make sense then. If I were a program and I could have do some calculations and feel confident, that would be a lot easier than trying to describe everything and not being certain what the ultimate outcome would be.
Right. Brady, you have your hand raised?
Sure. The only concern I have with the example of significantly revising the wording to do total volunteer legal services hours, both attorney and non-attorney exceeding total legal staff services hours. If we did that and got rid of the threshold test, then again, it's probably not a likely risk, but you'd run into a situation where you could theoretically run into a situation where a grantee that relied, entirely on paralegal volunteers would meet this test, but they wouldn't meet the statutory definition of providing of private attorneys providing free legal services. So that's just a concern that you're creating a loophole that might be avoided otherwise.
That's a very good point.
Yeah, I mean, that's likely why it was structured the way it was or the way it is now, right? To kind of keep the staff attorney part in there. Other comments or thoughts?
Heidi has another comment.
Yeah, go ahead, Heidi.
Yeah, I understand the point about the if you modify it to significantly revise, maybe just changing the calculation of the attorney equation might be something. We have a very robust law student program, and so that's definitely, and there are certain times when we can be right on the edge of that 50% attorney thing. So I guess if there were another sort of way of thinking about how to ensure the attorney component, but maybe still allow, maybe allowing the total hours versus total hours to be more of the, have more weight, I guess, is sort of, bring in some, you could make it some of the threshold language or something. I don't know. Did you meet 30, X number of, attorney sort of hours, and full threshold language in there to sort of ensure that you're not going the paralegal model like the gentleman suggested.
I see. So you're like one way to do it is to switch test B where you say it's, you know, all one and all other, so long as you have so many pro bono attorneys. You basically incorporate what is currently the threshold test into test B exclusively. You assume test A, you meet principal, means, and substantial numbers, although I have a little bit of concern on that, but let's assume that's the case. And then test C you leave for like people who can't meet either of the other two. Brady, do you think that would satisfy your concerns about test B if we had some kind of minimum threshold just in test B?
I'm sorry, I'm eating here. I'm not entirely sure on the fly.
Okay, that's fair.
I've got a question. Why is it that pro bono attorney hours have to be more than half of staff attorney plus staff paralegals? Why not just staff attorney?
I don't know, and I don't think it was documented. I assume it's to hit the substantial number idea that like your pro bono attorney needs to be not just like, it needs to be more than just your staff, it needs to be that plus your paralegal, but like could we just do staff attorney? I mean, yeah, maybe.
That's what I'd be in favor of.
I mean, again, we don't have documentation, Jim, but what I assume, you know, when this was created 10 years ago and there wasn't kind of a holistic approach to legal services, it was really like the understanding then was just attorneys and paralegals that do the legal services work, right? And so the pro bono attorney versus everybody else that does the legal services work. Now we know it's more holistic than that, and it's beyond just staff attorney, paralegal. So
your suggestion would be something like pro bono attorney and paralegal hours, or well, with the potential changes to the definitions that we've already introduced, exceed staff and paralegal, I'll put that in quotes, hours. And
yeah, but I feel like is that too restrictive for programs? I'm just thinking out loud right now as well. It's because it's such a complicated issue.
What do you mean by too restrictive?
Like if we include more, it's gonna make it harder for programs, right, to meet this. If you say pro bono attorney hours are more than half of both staff attorney, paralegal, and all other.
No.
The suggestion was get rid of all the non-staff attorneys. So it'd just be
okay.
pro
Okay.
bono attorney hours are more than half of staff attorney hours. Period.
Gotcha. I had it inverse. Okay.
Yeah.
Okay.
That, and Jim, that was what you were kind of thinking, right? That's what I thought we were alluding to.
Yeah, because again, the goal of this is to promote pro bono attorney hours, right?
Yeah.
So
yes,
I would think more programs would apply.
I think, but if I may interject, isn't the purpose of test B is to be able to integrate the non-attorney hours? Because that's been so important to a lot of our programs. So
Yeah,
eliminating it, wouldn't that make it more like test A?
I think, isn't though it's two parts, right? You count in the first half the combined numbers, and then you say, and in addition, the pro bono attorney hours are more than half of the staff attorney hours.
Okay, so you're not saying to eliminate the first part.
I think it's just striking, it's a two-part test. You combine everything, and the pro bono and paralegal hours exceed staff attorney and paralegal hours. And then on top of that, the pro bono attorney hours are more than one half. So 50.1%, percent of the staff attorney hours, to make sure that you're focused on pro bono attorneys and not having a program that's just paralegal.
but the two-part test nature of this, makes it really hard for everybody to understand.
Right. I think it needs to just be clearer.
Yeah, I just think you almost have to put it in like a 1 and a 2.
Yeah.
And you have to meet part 1 and you have to meet part 2. When it's one big long sentence, I think it's confusing, but I think there's a way that you essentially show a box that how you meet both of those. So you show your program's total pro bono attorney, and you show your total attorney and paralegal hours for the program, and then you show the total pro bono attorney and paralegal hours, right? And that's the first test. It has to exceed that. And then the second test is you look only at the pro bono attorney hours and the staff attorney hours, and it has to be above 50% of that. And so it's just two sets of numbers that you're going to compare that I think they seem straightforward to me.
Or you have your hand raised?
So does Heidi.
Okay, let me go Corey and then Heidi. Thanks. Kim.
I mean, is there, other than the fact that it's kind of awkwardly phrased, is there a problem with this? That like, do we need to? I mean, tinker with whether it's pro bono hours are more than half of staff attorney alone or staff attorney plus paralegal. I mean, as Catherine was just saying, I don't think this is all that complicated. It just needs to be, you know, B1 and B2. It's not that elaborate. So
yeah, I think that's right, Corey. I think we were saying though, for the what you call the B2, which I think is helpful, is that the pro bono attorney hours are compared only to the staff attorney hours.
right, but that
Right.
would make it a harder test to pass though. Is that okay? I mean, right now, not that many programs are qualifying by this method anyway. So
I thought it would make it easier if we got rid of the paralegal hours.
well, isn't it pro bono hours? Oh, maybe I have that backwards.
Right. So if you you might only have 100 staff attorney hours and you have 50 pro bono hours, but if you add paralegal into that, it's
right. Got it. Sorry.
200, yeah.
50 versus 25% or something, right?
It's been a long week, I guess.
No, it's complicated. Like
So I want to give Heidi a chance, and then Brady, I don't know if you, yeah, okay. Heidi, go ahead.
Yeah, again, it seems like a very simple formula, but you have to really be sure you're paying attention. Otherwise you get lost on it. Trust me, I understand. I just would like to say, as a provider who is a test B provider, typically, I would be in favor of the Meeker formula, where you eliminate the paralegals in the second part of test B. As a method that does make it easier to qualify under test B, maybe then you might have more people or more organizations that would qualify, because I do know sometimes that 50% threshold in part 2 of test B is an obstacle for us sometimes. So I would imagine there might be other organizations that would benefit from eliminating staff paralegal hours in the second part of the equation. And that might just be the simplest way to make test B more usable for the various organizations, or accessible rather.
Thank you. Jim and then Brady.
Yeah, I just had a question for Heidi, why she doesn't qualify under test A.
Our attorney hours, so let's say in a typical year, our volunteer hours are in the range of 13,000 to 15,000. Of that, our volunteer attorney hours tends to be about 60% of that, because such a large portion of our volunteer program is law student based. We have a very robust law student training program. And so they provide about a solid 40% of our hours, whereas our staff hours typically is about 12 to 13,000 hours. So I just don't have enough attorney hours to qualify under, or volunteer attorney hours to qualify under test A.
Gotcha.
Brady?
I would have some concerns, and maybe perhaps not insurmountable, but if we in the second part of test B, if we removed the staff non-attorney hours from that, I would have concerns that we would no longer be meeting the statutory requirement that these programs be showing that their primary means of delivering legal services, coordination of the recruitment of substantial numbers of attorneys in private practice. In other words, we should be comparing the way to stay most true to the statute is comparing the number of hours of pro bono attorney work to all the other staff legal work that's being performed, and figuring out, is it more than half or less than half?
So isn't that what the first half of that does?
No, because you
No.
could do everything with non-attorneys.
Right.
Non pro bono attorneys. Or I mean pro bono non-attorneys. Meaning you could recruit like 100 pro bono interpreters and 1 pro bono staff attorney, and that would be more than your in-house. But you've only recruited 1 pro bono attorney, and maybe that pro bono attorney did 50 hours and your staff did 95 hours. You've only recruited 1 attorney.
I'm having a hard time seeing, how the first part of test B really adds anything.
Yeah, I was just gonna say that, should we eliminate the first part and just keep the second to simplify?
But then you're just test A again, right? It's just a harder way to do test A.
Yeah, it's harder because why are you discounting the non, I mean,
Well,
why is the pro bono attorney work have to be more than your staff non-attorney work? That doesn't make sense.
Because the statute refers to using recruitment of attorneys in private practice as your primary means of delivering legal services. So your means of delivering legal services include non-attorneys providing legal services. But,
yeah,
the question is whether pro bono attorneys are the primary means. And that's that's what the statute says. Maybe there's a looser way to interpret that. I haven't really thought of that if you want to push it, but that's just what the words say.
I think there is a looser way to
Interpret that. I mean, if the pro bono attorneys perform their legal services by using paralegals and other staff, they're performing legal services. They're being done under the supervision of an attorney.
That's a fair point.
Okay.
Yeah, so basically, as long as you keep the nexus that it has to be legal services, as Eric points out, all of it would have to be under the supervision of an attorney. So you have 1 attorney who's supervising a bunch of interpreters, for example.
Well,
it's kind of messy.
I mean,
our
are pro bono attorneys actually supervising?
Yes, sometimes they do. Yes.
right. So that, I mean, I guess it would depend. So it would be if it's a pro bono attorney who's also utilizing the staff time of his or her own paralegal, and so you're getting volunteer paralegal hours out of it, then Eric's comment is on point. If it's somebody who's not an attorney who just happens to be volunteering, then it's really not.
I mean,
and I think it's actually, I think Eric's point makes a lot of sense. When you have, now that I've asked the question, and now I think back to my own experiences, pro bono attorney might see the client, fill out some forms, and then hand it over to a staff paralegal who's now supporting that pro bono work.
Yeah. So this is not maybe something to read, but I'll just say generally, like, if the statute says substantial numbers of attorneys, all of our stuff is based on hours performed, not numbers of attorneys. So in the principal means test. So I just want to say, like, that is, if we're going to go with the statutory language, like something for us to kind of keep in mind too. Like, this doesn't have anything to do with the number of attorneys on either side. It's all hours, which may be a sufficient proxy. And maybe this is we need to worry about.
I guess I think of it as recruitment of a substantial number of attorneys. Okay, you're doing that. And then is whatever you get from doing that your primary means of delivering legal services, which
yeah.
your hours could tell you that. But I'm satisfied based on Eric's comment and thinking on it, there is maybe some more wiggle room, arguably.
I mean, it could be, maybe it's just adding too much complication, but it could be, you know, paralegal hours, you know, it could be paralegal supervised by a pro bono attorney, as opposed to just a non-attorney volunteer who walks in the door. I don't know if that's necessary, because if pro bono is mostly going through the, you know, big law firm model, then that's not going to be the case. But you're not going to need to worry about those things. But if you're talking about just recruiting individuals, say paralegals or interpreters or what have you, then it's a little bit different. Then they're being essentially supervised by the staff attorneys.
But what is it? I guess the question is, like, does it matter if they're being supervised by the staff attorneys if they're still doing pro bono work? I guess because they're not bringing in pro bono attorneys.
Yeah, just because of the language of the statute. I mean, does
yeah.
it matter in terms of quality of services? I mean, that's a different question. I think it's the issue is the statutory language.
Yeah. Well, like I said, I still maintain that I'm a little bit concerned about even leaving test day without the threshold, because there's no numbers requirement there, but that's not what we're talking about here, but it sort of seems to touch on the same issue.
Yeah, I think that's true.
This is hard. And like Eric, Louise and I, you know, we spent like already a lot of hours, and the staff has spent a ton of hours, and we still haven't figured out how we're going to do this. Other thoughts, comments?
Erica, I don't know if I hear a leaning, so I'm having a hard time with this one too. Selena has a comment, maybe.
Okay.
I mean,
Selena, what's your thought?
I don't think my comment is especially helpful, but I think that a lot of these are confusing both for staff and for programs. And so to the extent that any of them can be simplified, I mean, that's better for staff to not spend as much time on every single application. I do have a little bit of worry if so many more organizations fall into Test C, just because of the additional staff time and commission time to review the Test C. But so not that helps with this particular option, but just kind of highlighting simplification is better, and let's try not to add several more programs into Test C as a catch-all.
I agree with that.
Can I ask, if while we're changing the IELTS statute for the income eligibility, could we maybe revise this a little bit? Is that, you know, anywhere within the realm of possibility? Because
it took a lot of work, Corey, to have community consensus and do analysis and to get the statutory change. I don't think my vote is not at this juncture, but I don't know, Selena, I'm curious your thoughts. It was a big heavy lift to get even that changed.
I think it would be tough, and the reason why is I don't think we'd have community agreement around this, because, you know, to make it easier for some organizations to get pro bono allocation is great for them, but if they are new to the county or a new organization, then they're essentially taking funds away from other organizations. And so the organizations that are not pro bono organizations may not want it easier for the pro bono organizations to get that allocation. So I think it would be hard to get community agreement, and I think it would take, you know, perhaps even several months of discussions and more modeling than I think that staff is capable of doing with so many variables.
Right. I mean, now that you say that, of course, this is going to be something where inherently there's not going to be agreement in the community, because, I mean, yeah, there's going to be winners and losers.
Selena, isn't it? I mean, unless a county has no pro bono programs, shouldn't the non-pro bono programs not care because they're not getting it? It's the current population.
Not necessarily, Brady, because if you make it easier, they might now qualify it's very
No,
complicated.
I thought I heard Selena saying they wouldn't want to make it easier, which I think the only people who would not want to make it easier are those who clearly qualify, and there's no question that they easily qualify under all these tests.
Well, except that once you start talking about changing this at all, you raise the question of whether there should be this allocation, and there you're gonna get disagreement.
Right.
Yeah.
Heidi has a comment.
Yeah,
But
given
I
all, I kind of go back to my original sort of thought process is just include the threshold barriers in as part of test B, make that part 1, and then part 2 can just be the total volunteer hours versus total staff hours. And then that way you are protecting, you know, sort of the primary delivery based on attorneys. Or meeting that delivery, but also, you know, sort of allowing for just a straighter, clearer test.
Yeah, I think, but Brady, weren't you saying part of the concern is that your principal means has to be recruiting pro bono attorneys? And like, that's where I think the issue is, if you meet the threshold, say we use the thresholds we currently have, 5% or something, but you still are vast, like the way you get over the hump is law students, you know, Heidi, to use your example, but not actually attorneys. I don't know if that and I defer to Brady on this, whether that would comply.
So let me ask, and I don't know this, apologies for not knowing the nuts and bolts answer to this, but in the initial accounting of pro bono attorney hours, or excuse me, staff attorney hours, are we letting applicants, grantees take out the staff hours that are spent directly supporting pro bono?
No, that's one of the issues that we were discussing in one of the proposals, and we ultimately were not prepared to make that change and to raise it as a test C issue.
Because it seems like that sort of,
yeah,
and it might be hard to implement, but it sort of answers the criticisms of this test as being too harsh, that you can say, oh, you know, if these staff attorneys and paralegals are really, or staff, you know, paralegals especially are really just supporting pro bono work, then
at least they don't, even if you don't count them as pro bono, you don't count them as staff. They end up in like neutral territory.
Yeah.
Right, you just reduce the denominator instead of both reducing the denominator and increasing the numerator. But there were concerns about that.
Well, I'm still in favor of keeping test B as modified on the second part to exclude the paralegal hours. It seems like it works for a couple of programs out there.
I will say I'm in favor of that as a policy, but I defer to Brady on whether if that change is legally supportable under the statute's language.
I'm not prepared to.
No, I
I
understand.
mean, it sounds like it's certainly arguable.
Yeah. Other thoughts? Anybody else have? How do we feel about it? Like, assuming that, you know, like the threshold test, we can kind of we'll do a little bit more analysis, make sure it's legally supportable. Do people feel comfortable with the suggestion of just tweaking test B to get rid of the paralegal hours in the second part?
Oh, it's Catherine. I previously agreed with Jim and
Yeah.
still do, assuming that it doesn't pose a legal problem.
Okay. Louise, Corey, do you guys have thoughts?
Yeah, I agree with, I agree with the proposal to remove the paralegals. And I think this particular, I mean, that language to me, I had to read it a lot, many times to actually grasp it. And another suggestion was to maybe put it in two parts so that it's clear that there are two prongs to this test. So there's an A and B or 1 and 2, and remove the paralegals.
Yeah. Corey, do you think?
Yeah, I'm comfortable removing that part, but I'm like you, Erica. I'm still thinking about how substantial numbers fits in back in again.
Yeah. But I mean, I think that problem is also true for test A, if we get rid of the threshold. So
Yeah, I mean, I think it has to be. I think it has. Like I said earlier, you know, it kind of maybe depends on how this works out in a factual circumstance. That like 1 is probably not substantial numbers, and in some of these circumstances, you could end up with 1 theoretically or 2 people.
yeah.
But couldn't you argue that, I mean, if so take test B as modified by, as suggested by Jim, if your pro bono attorney hours are more than half of your staff attorney hours, then how could your number of pro bono attorneys not be substantial? I mean, they're, however many there are, they're performing half the work
Well, just
of your attorneys.
I mean, yes, that's right. But except that it says substantial numbers of attorneys and not, you know, which implies numbers of humans. And I mean,
yeah,
like what you're saying makes sense. I would write the statute very differently.
Right, pro bono services, right?
Substantial amount of services, or
yeah, exactly. But the numbers of attorneys sounds like we're talking about counting heads.
Right. I mean, the problem is that we know the legislative intent is we want to encourage leveraging of dollars to, you know, encourage more pro bono, which but then what they're saying is maybe like sometimes their specifics go off in a slightly different direction than that. But where there's statutory language, you know, I think we have to make sure that we acknowledge it.
Yeah.
It doesn't have to be necessarily a specific definition or anything like that, but that it has to be incorporated into the test.
Let me say, if we think there's like a credible argument that so long as pro bono attorney hours are more than staff attorney hours for test A, and then, you know, to meet the second part of test B, that meets the substantial numbers, like I'm not opposed to it. I just want to make sure that we're on like good legal footing on that. That's my concern.
Again, not ready to give an opinion, but
no, that's not, I wasn't expecting you to do that right now, but I think.
No, I was just going to say part of the, yes, we wish the statute were written better, but part of the beauty of it being written so poorly is because it's so unclear, there's lots of arguments for what it could mean. Right. Because I mean, it says that the services described in 6214 need to be our primary means. Well, the services, it actually says the coordination of the recruitment of substantial numbers of attorneys. Does recruitment mean that you actually got them, or that you're out there asking them to join you? I mean, you could go down a rabbit hole with that language.
So yeah, I guess I think there's not going to be a legal answer, probably. That it's not like there really isn't going to be a definitive answer.
Right.
And so our rules need to be phrased in such a way that it is clear that we are addressing the language.
Right.
And as long as we're within that, and we're, you know, keeping in mind really the overall goal, I mean, the practical question is, you know, is anyone do we think the legislature is going to object? Do we think they're going to the judiciary committees in the Assembly or Senate are going to complain? I don't think so.
Right.
But it has to be phrased in such a way that we are acknowledging that it does refer to numbers of persons. And I don't know where is the best place to put that in, but if you've got tests where it could be a single person, there needs to be, I think, some other thing, even if it's just, efforts to recruit multiple people or something, but it does seem to imply we want a bunch of people. I think our full drafting here is could get us there.
So I want us to be cognizant of time and the fact that we have like a whole other proposal to get through. So I guess maybe it sounds like people are, more inclined to go with this test B, but getting rid of the paralegal hours at the end, but subject to that being consistent with the statutory requirements and potentially maybe in the commentary to the rules. I think usually these rules come out with like commentary or something to them. We could maybe address that we think hours is a sufficient proxy for numbers of bodies and, has an ease or something along those lines that would address that we have thought through why we're doing it this way and not literally counting heads.
Mm-hmm.
Yeah, as we move into the state bar rules, we probably will be getting rid of the official commentary, but
okay.
It could be part of the legislative history, regulatory history.
Just if we get sued, you want to know that. I don't think we'll get sued, but you gotta.
Yeah, I just think if you're going to do that kind of commentary, I mean, we started this whole discussion way back at 10 with the particular impact this had on rural communities. And so somehow that concept of it has to be incorporated. Like if you only have 3 lawyers in your county, your ability to do this is going to be quite different than LA County.
Right. Okay. Why don't we, so if we are going to keep this test B, then we need to just remember that we have these other definitions that we need to include as well, which is all non-staff, all non-attorney hours that are related to legal services and law students being included as pro bono, right? Those are the other 2. Judy, am I missing one?
Yeah, no, the test B expanding non-attorneys and the law students as pro bono volunteers.
Okay.
Would apply to test B only. And then also under the definitions, we have legal fellows as staff attorneys and whether we consider staff pro bono work as pro bono hours.
Yeah. Okay, why don't we, is there more that we need to do on the?
There is one final.
Okay, let's get through that and then we can kind of get our recommendations together.
Okay, and that is, do we want to add specific elements of a strong pro bono program as factors for test C? Because the numerical tests do tend to favor large organizations. They have more, resources, more time to follow up with staff, to have these sophisticated tracking mechanisms. And test C could be expanded to include salient elements of what we perceive to be a strong pro bono program. And those factors may include recruitment and retention, a specific training curriculum, a variety of volunteer opportunities available, a model that actually requires volunteers, and then details about the supervision and scope of support for volunteers. And these factors would point to the organization's true investment in their pro bono delivery model and whether in fact the program was sustainable without pro bono support. We propose this not be an exclusive list, but organizations could still continue to describe their own methodologies if they desired. But these factors would provide the commission with clearer standards to assess Test C. It would provide consistency and some objectivity to the commission's adjudication, and would also add transparency for grantees. The community did not have feedback regarding the specific option, but given their general comments, it seems likely that they would be in favor of maintaining an option that allows flexibility and consideration of unique circumstances. The recommendation from the working group is to adopt this proposal because it would set clear standards to assess Test C applications.
It's Catherine. I guess one question I have, and it might be because it's outside of just the tests, but is there some place that the bar knows, like in the end, how many cases did pro bono staff handle as a way of demonstrating kind of a primary purpose? Is that part of any of this that you collect data on?
I'm trying to think if it's coming out of our case summary report. Elizabeth, are you on? Is it cases closed in the case summary report, the pro bono?
I'm sorry, I don't quite understand Catherine's question. What data are you asking about?
For the pro bono attorneys, is there to me, one way to demonstrate that this is a substantial way that you, Heidi already said, we don't report a measure on how many cases did pro bono attorneys handle. So that's really my question, because that's a way to demonstrate like it's a substantial part of the program. Like we did 100 cases, direct representation cases, and I'm not talking about all the training. And of those, 60 of the 100 were done by pro bono lawyers. That's persuasive to me. And I'm just wondering if that should be a factor in this Test C. Like what's the outcome to the clients kind of?
That's a good point. That's a really good point, Catherine. I don't think we collect that data. We don't distinguish between pro bono and staff.
Heidi said that you don't collect it, so I'm just.
Well, I know we don't collect it in terms of measuring for this, but I think I'm not 100% that we don't collect it in general. That's what we definitely don't collect it to determine pro bono allocation, but I can't remember if we.
I don't think we make that distinguish. We don't distinguish that in the CSR.
We don't in CSR. Okay.
We don't. I had asked programs that have looked for technical assistance in applying under Test C to describe how many of the cases get touched by volunteers and to what extent the volunteers support the cases. So that's something that informally we've shared as a factor to encourage Test C, but we haven't formalized it.
So Dan, I think I'm agreeing with you that there ought to be a way in Test C to show kind of exactly what you're saying, which is our delivery system looks like this. We, as an organization, did this much direct representation, and of that work, here's the amount, the percentage, the something that pro bono attorneys did.
There are so many different models, but something that would give that vision.
Yeah.
I think that's a great idea, and it would be great to solicit something like that as one of the factors that could be provided. Like what are pro bono? How in depth is what the pro bono's attorneys are doing? Actually, I mean, it's are they providing brief advice and counsel, or are they the ones who are actually delivering the services? I think would be just really good information to have. And I just wanted to note also, we've had an issue in the past with at least one provider I can think of being mysteriously unable to provide information about the activities of its pro bono staff and not even asking them for hours. And I understand that very careful monitoring of hours is difficult for smaller programs, but maybe something about at least efforts to track things. And I don't know, maybe that was one of the proposed factors. But
Corey, just to your point, I think, I mean, it would be another metric for programs to track, but presumably if a program is referring a case to a pro bono attorney, it's still the organization's case. And so they should still be tracking outcomes. And it would just, the extra metric would just be like to mark it as a pro bono case so that they could report it to us as one.
Oh, yeah, I wasn't referring to
Okay.
the outcome measurements. I was just referring to, you know, a program that was like couldn't describe how many hours. So they were coming under test C because they said, well, we just don't know how many hours that our pro bono attorneys spend. And maybe they don't know, but it seems like some kind of, if pro bono is one of your central concerns, then you would think there would be some effort to gather information back from the pro bono attorneys rather than just, you know, here it is and see what at the end, right? So
definitely.
So some kind of factor that would maybe you know, maybe solicit that kind of information, like what see what the level of interaction is, and to make sure people are at least, you know, maintaining that relationship and trying to get information as opposed to, oh, we just don't know. And I maybe it's not a good idea to build language around one particular program, but it's just something that I recall.
I just think having some data in addition to these other kind of factors, all of which are fine, just helps support that this is a primary method of you providing your services. And I don't think it's that hard to collect the data based on what matters was a pro bono attorney involved in, you know, with or without other staff. It seems like you would want to know that as a program just for quality management. You have to know what are your pro bono people working on. So anyway, I just think data would help.
So Catherine, would you make the data reporting a requirement? Like, because right now it says factors that may include, but so would it be factors shall include, you know, the reporting of the data, and then the may would be the rest of this
Maybe, I think
pointed
so.
list?
I feel like some data is helpful and gives credibility, even to Brady's point about like consistent with the statute, that this is a significant way that you're providing your services.
So what if one of the factors was factors may include, you know, the degree to which a program maintains information about what pro bono attorneys are doing, and something along those lines. It's just like,
I would really just say factors shall include, you know, like demonstration of, I haven't really thought through how to measure it, but you know, Dan had some good ideas about the number of matters handled or the impact or something about what your pro bono attorneys are doing. And then other factors may include these other kinds of things. But
yeah,
I feel like some database thing ought to be part of this. And it's certainly going to be easier to explain if the legislature ever asked a question, having something that you can say, it was this data that was required, and then there's these other things, I think helps the bar.
Yeah, the other nice thing about saying factors, just more generally, like shall include, is I think it gives the commission more structure and the committees more structure when they're actually making determinations, because like these things are really, like, having done a few of them, like they're just really subjective in a lot of ways. And so if we're required to go through like half a dozen factors and actually say like, okay, here's why, you know, here's what we find here, here's what we find here, and then in total, this is why we came up with yes or no. I actually think that's good, rather than, and if they don't read, let's put it this way, if they can't address these factors, like, should they be qualifying under test C? Like,
right.
Right? Like, we don't want test C to, you know, become the exception that
Eats the rule.
Eats the rule.
Yep. I think everyone likes the idea of having specific factors, though.
Yes. And I think it should be shall, like the that they need to provide this information. Not that they have the option to, they should provide this information.
I think we can start off with a set of factors, but I think that's probably going to be modified under practice. I think the eligibility and budget committee ought to every year, when they look at everybody applied for under C, and the ones they approved, why they approved them, and the ones they didn't, why they didn't, and modify the factors appropriately.
Yeah, I mean, if this is gonna go through like regulatory process, we may not want to change them every year because obviously the organizations need some consistency, but I think you're right that you could do an audit every year and then every, 5 years or something, you revisit and make some changes and adjust. But I think having a set that you're like, we want to know, do you have a recruitment and retention strategy? Do you have a training curriculum? And if an answer might be no, but you still should qualify because you're really strong in other factors. But to Catherine's point, knowing what people are doing is probably not the worst thing. Having said that, is that going to be difficult for the organizations to comply with? Any other comments? I mean, I don't know what.
I just have one more comment because
Yeah, please, Selena, I'd love to hear your thoughts. We're all like, I'm like, yeah, but what do you think?
Well, I mean, there's so many different options, and I think I shared with you all that because you wanted a lot of different options, the memo felt really dense, and it was hard for a lot of programs, whether they're pro bono allocating programs or non pro bono allocating programs, to really think through how would this impact my program or how this impact my county. So I think that once we kind of distill it down to like the very clear recommendations from this group to the larger Legal Services Trust Fund Commission, I think then organizations can be more clear to say, this is how it would impact. This is how it may be easier for reporting whether or not we get pro bono allocation now. Because I do still worry about TESI just becoming so much staff time and commission time that adding some of these metrics will just help make it really clear.
Yeah.
And another thing, which I think I mentioned in a prior response or email, is that I think pro bono organizations want to know, are they going to get pro bono allocation or not? And if they're in the gray area, then they don't know whether or not they need to be counting some of those clients that are above income. And so the clearer we make it, the better, acknowledging that some organizations are going to have to get under TESI and they're going to be gray no matter what.
Okay.
Yeah.
So Eric, can I make a suggestion? Because this is really dense and we have a lot of options and it's really complicated. But when we go to, can we, I know that there was consensus on a number of, so
yes,
we can get approval in concept on like the ones that we have consensus on. And then perhaps staff can work with the working group to package it for the commission, but it not roll back to the rules committee. Because there's going to be questions that come up as we draft and as we work with Brady to kind of redline the guidelines.
That's a great suggestion. So yeah, why don't we make our motions on the stuff we agree on, figure out what we don't, and then the working committee, we'll get to revisit this. Okay. Yeah.
So Judy, can you just recap everything that was let's recap everything that we have a consensus on. There was a leaning, and then we do a motion, and then maybe we do recap on the things that are still outstanding. So then we're really clear what the working group is going to be working on.
So my understanding is that we were clear on the threshold test in favor of elimination. And Erica, as the note taker, feel free to chime in.
I think there was subject to some further analysis that wouldn't upend other substantial numbers issues. That's the only wrinkle I would add.
And then with regard to alternate principal means, doing a test day based on number of clients served was a no.
Yeah, that's correct.
Not in favor of that. Legal means. And then I need to go back to, let's see, slide 22. With the definitions, let's see, with legal fellows, see.
I think the leaning on legal fellows was that that was something that could be addressed under Test C. You know, if there is an organization that is sort of
Okay.
on the cusp and, you know, that by counting them, it would, you know, knock them out of contention, that they can explain that in Test C.
Right.
Okay.
And Erica, just to add to that, I think the default was that the staff is that legal fellows would be counted as staff attorneys. And if there's some issue, they can be explained in Test C. So the opposite of their recommendation.
Yes.
Wasn't it legal fellows would be counted as staff attorneys if they were attorneys, or we're just saying all legal fellows?
I think we just said all legal fellows.
Yeah.
If they're not attorneys yet, I don't think we should count them as attorneys.
Either do I. I think that gets very confusing in terms of the different parts of the forms. I mean, I think legal fellows get counted if they're
Yeah.
attorneys. Attorneys get counted as attorneys and non-attorneys get counted.
I
as-
think that's fair. Yeah.
Okay.
Okay. Okay. And then whether we were, let's see, slide 28.
Sorry.
Lost students as volunteers, I think we're in consensus that yes, we can include them as pro bono volunteers, even if they get a small stipend or course credit.
Oh.
The leaning was towards yes on that.
I think that's right.
Okay. And then pro bono work. Let me back up to this one. Staff hours is pro bono hours. That's too complex. Keep it as is for now. Was the lead.
Yeah, not to make the changes now.
Mm-hmm. Okay, and then we have eliminating or simplifying test B and specific elements for test C. Oh, and whether we want to expand test B to include non-attorney volunteers.
Well, it seems like test B we are leaving, right? We don't have consensus on that yet.
Yeah, that's what we have to work on that one.
Okay.
Yeah.
And then the factors for test C.
So we can keep these two together as work with test B. Okay. And then we have, let's see, B, our last. The alternate principal means factors.
I think this we have to work on, even though we're suggesting to change it to a shall instead of a may. But this I think needs to be worked.
You can work on. Okay.
I think there's agreement to do factors, but not what they are.
Yeah, exactly.
Yeah. Okay. So threshold with a yes if it meets the legal requirements. And then legal fellows as staff attorneys, keep as is. And law students is pro bono in favor of. Staff pro bono hours as regular hours, keep as is. And then a no on the number of clients served as a test A.
Great. So do we need to do a motion for these?
Brady, we should do a motion, right? Just to capture it, because then we have to move it along to the commission with delegation of authority back to the working group to finalize with staff.
Yeah, I would support that.
Okay. So the motion would be to approve all the areas that Judy just summarized and all the outstanding issues. The working group would work with the staff to finalize recommendation to go to the commission.
Okay, I'll make that motion.
I will second the motion, Catherine.
Great. Let me do roll call vote. Amin, Luis,
Yes.
Catherine,
Yes.
Erica,
Yes.
Corey, Jim.
Yes.
We have 4. Motion passes.
Great.
Okay, so we're at the end of this agenda item. So the next one up is Dan exchange funds, Erica? This one
Yes.
is pretty straightforward. It's not.
Yes.
Okay.
Hi,
Did you want
everybody.
to run through it?
Sure, thanks very much. Let me see if I can share a screen here that would be helpful and give you a bit of a PowerPoint presentation. Oh gosh, now it's not letting me get in there and start my slideshow. I'm going to stop sharing for a second.
No.
It's
We can see it, Dan. It's
Yeah.
blank, but it says you've started screen sharing.
Yeah, but now all of a sudden I've got this little rotating button that's not letting me go through. I've literally been practicing this for the last 3 hours. But let
my
me.
deposition yesterday.
Because you wore it out. You practiced so much.
Here we go. I'm just going to do this using the PowerPoint screen and not a slideshow because it's acting a little funny on me. But we have just had a really complicated conversation. We're about to talk about something else that staff have found really complicated, but the conversation is going to be a lot more straightforward. The whole point here is to take something that was complicated, try to make it a lot more straightforward. Very briefly, here's what we're going to go through. Our basic terms of art, how this issue of how expenditures impact what we're doing, how exchange funds impact how expenditures work, and then what we've been doing about them and what we might want to do about them going forward. In brief, these are the rules that we want to follow. Section 6213, A and B describe the primary purpose and function. It describes a set of activities that we call qualified activities. And that's what you have to do as your primary purpose and function to get a grant from us. Section 6216 tells us how to allocate the grant funds if you meet one of those definitions. And finally, State Bar Rule 3.671 establishes a presumption that if an applicant establishes that 75% of its expenditures and budget were spent providing those qualified activities, we presume that they're qualified. These are the basics, and I think we're all pretty familiar with them. Also, I want to explain, just to make sure we're all on the same page, how we allocate these funds. For QLSPs, funds are allocated across the whole state among all the counties based on their relative indigency, and then within each county, the funds are allocated to QLSPs based on their relative qualified expenditures, their expenditures for those qualified services. That means that an organization, QLSP, that has larger expenditures will receive a larger share of a county's grant. Support centers have a much simpler system for allocating grants. We simply divide the amount that's available to them by the number of organizations that are eligible for it. It's straight division. With that in mind, I'd like to move forward to where it gets tricky for us. When QLSP grants are calculated, before we actually run the numbers, we have to take additional deductions because if we don't do so, we're going to start straying from the way the statute is supposed to work. There's a couple of different things that we pull out. We take out Shriver funds because the Shriver statute says so. We take out IOLTA and EAF grants, our own money, because we don't want to bootstrap and give existing grantees an advantage over new grantees or new applicants. We also take out funds that are exchanged between two organizations that are both applying as QLSPs. We do this so that when one QLSP gives money to another QLSP, we only want to count it once when we allocate their grants. And here's a beautiful, cheerful picture to explain how it works. QLSP1 pays money to QLSP2. QLSP2 does the service. Both of them can show on their audit that they spent that money. It'll show up as a lump sum payment for one and as part of their staff and expenditures for the other, but that money will be in both organizations' expenditures. And the services have only been provided once. Why is that a problem? It's because when you count the money twice, but the services are only provided once, it is not consistent with the legislative intention for the IOLTA funding statute. The QLSP funds are allocated based on organizational expenditures because the legislature thought that this was an objective and non-discretionary way to allocate funds. We've gone through, I'd say, probably 800 pages of legislative record, and not once do they mention anything that might make an audit report anything but a purely objective, non-discretionary, tool and presentation of the facts. And in a lot of senses, that is true. An auditor always makes sure that the numbers add up, but that's not what the legislature really had in mind. The legislature was thinking that services, that payments lead to services, and there's a one-to-one correspondence. The more services you provide, the more money it costs, the more money we'll give you. If two organizations both credit themselves with the same expenditure for the same services, it's no longer unique, it's no longer objective. We could start trading money around and have it repeat itself as many times as we want. Because we only want to have unique expenditures for unique services. Since the beginning of this program, we have required organizations to identify when they've traded money between themselves, and one of them needs to deduct it. And before I go any further, I just want to make sure that there's no questions or anything else that we want to go over more carefully.
I just want to, it's just, we don't want them, we don't want the services to be double counted because the amount of expenditures goes to determine a grant award. So if 2 programs or 3 programs are counting it, then it's going to be,
Yeah. So one set of services, one person gets to count it, or one organization gets to count it. However, the statute does not make any specific allowance for this. So we have done it on our own. Since the very first year of the program in 1983, funds between, this is 1983, funds between any 2 applicants could be counted for by both for eligibility, but they had to be declared and one of them had to deduct them for grant award so it wouldn't be double counted. We don't have paper records going back to 1983 showing all of the applications. I have seen an application from 1990, and that was no longer happening for support centers. It was only happening for QLSPs. But in 1983, it did start with both kinds of organizations. And as with our other conversation, I don't find any record of why that happened or when. But we are still doing it for QLSPs, which both must require, disclose that they had this transaction, who it was with, and how much it was. We want a written agreement if the amount that was exchanged or that they're reporting isn't the same as on the agreement. Frequently it's not. We need an explanation from them. And if they don't otherwise make an allowance for it, the recipient gets to be credited with the money, but sometimes the donor insists on getting that credit. So this is a fairly well-structured process. However, it's not part of the state bar rules, and it is not as robust as potentially it could be. So as part of the codification process, we wanted to look at all the parts of the application process that are critical, and this is critical, but that aren't in the rules, to make sure that to the extent necessary, we're providing the community with a single source for clear information about what they have to do to qualify for these funds. Our first option with regard to exchange funds was just to scrap the whole thing. It's not in the rules. Why are we doing it at all? We're doing it because it saves the statute, because it makes sure that the allocations for QLSPs work the way that legislators intended them to, and that organizations that spend all their money providing services aren't penalized because other organizations that do other kinds of exchanges actually wind up with higher expenditures at the end. Staff does not recommend suspending the exchange fund deduction, and the working group supported that recommendation. We next talked about codifying the exchanged funds deduction. And at this point, I want to take a second and specifically thank the members of this working group, Erica Connolly, Zahara Mann, and Richard Reines, who really know their stuff and had a lot of great suggestions, additional advice for us. And some of their ideas are some of the reasons why the pass-through memo isn't here today, because we wanted to make sure that some of what they had added was included in what we were working on. If we codified the exchange funds deduction as it currently exists, we would recognize many advantages and benefits. It would formalize this practice, make it clear to everybody in the community, to members of the commission and to staff exactly how it works. There would be less ambiguity, less opportunity for inconsistency, and it's better to have all of our rules in a single location. So why not just do it like this and codify what we've got? The group considered that there would be an advantage if we actually made this process more robust and expanded it to all applicants. By doing this, we would first make it fair for everybody, that the same requirements would be imposed on all applicants. It would be a single standard of fiscal transparency, so we would see everything with the same lens and understand organizations' fiscal standing and status, whether they were a support center or QLSP equivalently. It would be consistent with the statutory intention and all of the other advantages from option 2, but it would also give the commission much better information about how the organizations work together, help each other, where funding is being used and where it is needed most. So as funding programs come before this commission, this information could help with understanding how best to approach the distribution or the plans for other funding that might come forward. Finally, I would want to underscore that when we shared these ideas with the Legal Aid Association of California, they had only one comment, and it was, let's go with option 3. So that was where we wound up. Option 3 would potentially take one of our state bar rules. Rule 3.671 is called the primary purpose and function rule. And it currently has a section that establishes a presumption of eligibility for QLSPs, and then one just the same for support centers, and then one for programs that don't have 75% qualified expenditures. We are thinking of revising that rule, restructuring it in some way so that there would be a new section that identifies funds that would not be included in the primary purpose calculation. And those funds would be exchanged funds for purposes of this conversation. And here's what we're saying about them. Exchange funds are funds exchanged between any two organizations seeking eligibility for IOLTA grants, not falling under any of the following exceptions: pass-through expenditures, which we're not going to talk about today, payments of funds allocated under section 6216, which would be IOLTA grants or equal access fund grants, and funds received under any program which prohibits those funds from being credited toward IOLTA grant allocations, which would include Shriver grants. Any funds exchanged between two applicants and not falling under any of the foregoing exceptions must be reported by both the payor and the recipient. If both parties are QLSPs, one of them must deduct the transaction for purposes of calculating grant allocations. In such cases, the funds will be credited to the recipient absent a written agreement to the contrary. This was written to replicate as closely as possible, in as few words as possible, what we're currently doing, with the only exception that it is being expanded to all applicants. This rule is in a section of the rules that's about applications, so it's pretty clear from the context what we're talking about. But I wanted to stop here for two reasons. It is my last slide, and it's a good chance to ask whether there's questions, concerns, or comments about this proposal.
Thanks, Dan. Anybody have thoughts or comments?
Let me stop sharing. Should I stop sharing the screen, or does this help to have it up here?
Well, I just want to make sure I understand something, Dan. So Erica, whenever you, sorry, I didn't raise my hand, but
It's fine, go ahead.
I apologize. So the last sentence that says, if both parties are QLSPs, one of them must deduct the transaction for purposes of calculating grant awards.
Yes.
So that language is not applying to support centers then, is that right?
That's correct. Support
Because
centers
Because it's
don't.
divided equally by the number, right? Okay, but what if one is a QLSP and one is a support center?
The reason that funds are deducted is so they don't get double counted. And since support centers don't count funds,
So
it would be
wouldn't
it wouldn't be a
except for
problem
one.
if a QLSP counted it and its partner was a support center, because those funds would only be counted once in the course of calculating the grants for that year.
Okay.
Even if they were both QLSPs, you'd count the money for their primary purpose. That's the same as for a support center.
You know what? I think Catherine does make an interesting point, though, because even if, Dan, what if the support center counted it? We don't know they counted it, but then the QSP also counted it. How would we know otherwise?
Well, I think that the issue is, are you counting it for purposes of eligibility for grants, primary purpose, or are you counting it for purposes of grant award allocations?
Yeah, but if the support center is counting it, and they should be counting it, say they were doing it correctly, we should have a mechanism so the QSP is not counting it, right? I think, is that your question, Catherine? I'm not
I'm
sure.
trying to, I mean, I will admit to, like, I'm getting a little tired, so I might not be clear, but I'm just trying to make sure I understand what happens when it's a mixed funding group. And I guess I'm not as clear about, so this section here, even though it's going under the primary purpose, doesn't relate to how you establish your primary purpose?
This says that, the new section of the rule would be instructions on how to count exchange funds when determining primary purpose and when calculating grant awards.
Yeah.
This would allow both organizations to count the funds for primary purpose, but only one could count it for a grant award. So as it's currently structured, the application process is a sort of a sequence of events where you start off identifying all the expenditures, determining whether or not you're eligible, and then QLSPs will take out a couple of extra pieces.
Yeah.
So once the support center has been determined eligible, we can already calculate its grant. No funds get to be counted or need to be counted, but we have included the exchange fund for both of them. Whether the exchange is between a QLSP and an SC or two QLSPs, everybody gets to count that money for eligibility purposes. It's only when you're calculating grant awards that you need to pull the money out so that it only gets counted once.
No,
So
but isn't a double counting issue though, like regardless of whether it's a primary purpose or calculating grant awards for QEs, like we shouldn't be double counting even for primary purpose. Like you should,
Well,
if it's one expenditure and one activity, you can't a support center and a QSP or whatever combination it is.
we have historically taken the position that it represents a qualified activity, and therefore we allow them to include it toward their eligibility for grants. But it may not be a qualified expenditure for both of those organizations because it may not count for both of those organizations. So if it doesn't, one of them should deduct it. The two-step process is, I think, where things really do get opaque. But first we determine eligibility, looking at all of the expenditures, and then we'll pull out some of them just for grant allocations for QLSPs. Eligibility is always included exchanged funds, even in 1983 when they were first identified for support centers as well. It was only for grant allocations that they had to be pulled out. However, if it is worth discussing that we might not want to have, we might want to make exchanged funds count for primary purpose only for one organization, that's a novel approach that has not been vetted to the community.
Dan, do you know do you happen to know like why you sort of got into this, but if you could provide just like a little bit more detail about why it seems appropriate to kind of allow the double counting at the primary purpose versus not allowing the double counting at qualified expenditures? Because that may that we're treating them differently, so it'd be good to sort of explain.
And this, I think, ties a little bit to the topic we're not going to get to today, which is pass-throughs. And it is essentially whether we're talking about something that the organization actually spent its own money on, and it's a valid expenditure for this organization or not. I'll give an example. One QLSP gives a bunch of money to another QLSP so that they can hire a staff member to maintain an existing project that they're doing. Both of them really did spend that money. And it wouldn't be fair to say to either of them that it doesn't count toward your eligibility. However, grant allocations are a zero-sum game. There's only so much money in each county. And when any organization, any QLSP expands or inflates its expenditures, the others around it will get less. So at that point, it becomes inequitable to the other organizations to allow two QLSPs to count the same expenditure toward their grants. There's no inequity if they both count the activity toward their eligibility.
Right.
But
there's only one set of services being provided with the money.
That's true, yes.
Which is why it's not appropriate at the qualified expenditure level to double count.
Yes, that's
Yeah,
right.
and I think maybe we're all saying kind of the same thing, because I think what we were doing before, the staff recommendation is that we should change the way we were doing it before, because it was treating support centers not the same way as QSPs. I mean, there was a reasoning, right? We thought we would be, for administrative reasons, it would be easier for staff as well as for support centers, because we don't need to nickel and dime them if they're going to meet primary purpose. It doesn't count towards their qualified expenditures, right? Because you don't calculate their grant award the same. But the thing is, in letting support centers not kind of count their exchange funds, we don't know if double counting is happening. So
Right.
Our recommendation is to move towards having, but then after that, I think we're maybe now there's a disconnect. So I think we're all in agreement with that, right?
Yeah.
We want to have kind of consistencies between QSPs and support centers so that we ensure that there's not double counting.
Yes, double counting
There is-
toward grant awards in particular.
No, but that's where I'm getting lost, I think, because.
Yeah, that's the piece I think now from
Right.
there, I think there's
you
some
say
confusion.
we don't want double counting, but the only time support centers reported is for their eligibility, and both programs are reporting it for eligibility, which may be fine, but support centers are not required to, for all the good reasons Dan explained, and I understand. They don't get their funding that way. So the double counting thing actually isn't really a reason.
So let me just say, my interpretation was we wanted the support centers to report that as like a data collection, just
I
to
think
see
that's
what's,
fine. I think that's
yeah,
fine.
yeah.
But it's not just for data collection though, because a few years ago, we had a support center that we found ineligible. We knew that they were going to meet primary purpose, but because we didn't have sections for them to deduct exchange funds, and they weren't really deducting everything because we were always lax about support centers because it wasn't a grant award. So, I mean, part of this is we want to have an accurate qualified expenditures number, an accurate QE number for support centers, even though their award allocation doesn't get counted like that. Because over time, there might be programs that start to go down below 50%. So you want to have a clean record, right? So if they're not really deducting exchange funds, or you're not going to get an accurate a QE number, even though it's not used to calculate their grant award.
Brady had a comment. Let me let him.
A question. Can you give me an example of when a exchanged fund transaction would happen between a QLSP and a support center?
Sure. I can think of two situations going in either direction. In one case, you might get a support center that receives a large grant from a foundation to support work in a particular legal area, and they connect with a bunch of QLSP partners as their subgrantees. Say, we're going to pay you to do this work in this area, or here's a bunch of money about immigration. Let's all get together and figure out how to spend it together. When the QLSPs get that money and spend it, that's an exchange fund. On the other hand, some QLSPs actually will receive subgrants, for example, a healthcare subgrant that would have a piece that is best run by a support center. So a QLSP might get a bunch of money from the California Coordinated Health Program and give a piece of it to a support center that has a specialty in healthcare, and another piece of it to QLSPs that are doing signups for Medi-Cal. So in that case, you've got a QLSP paying a support center, and both of them are honestly spending the money.
But I guess, Dan, so in your, now I'm like getting myself more confused. It's in the first example, so the support center gives the QLSP money. The support center isn't counting that money because that's not how they get their allocation, but arguably the QLSP is supposed to deduct it. So then nobody's counting it.
No, under this proposed rule, it only needs to be deducted if both parties are QLSPs. So, and this goes back to how each organization achieves eligibility on its own. We look at its activities and services, but when it comes to passing out QLSP grants, we need to make sure that nothing's being double counted and that we're being equitable to all of the applicants.
But then how is that an example of?
So the ETSI and the QLSP would both report the exchange funds to become eligible, and that's double counting. But then the double counting in the
but it's I guess depending on if the support center, like if you got $1 million, but you gave 3 grants for 250 and you kept it yourself, are you as the support center counting the $1 million, or are you counting the amount you retained as the 250?
That's going to depend on the terms of that transaction, I think. But
is it a pass through?
Well, that's a good. I was going to make a suggestion. Because I know we're 5 till and we're all really tired, or at least I'm really tired. We couldn't get the pass through recommendation together in time for this meeting. Really, the exchange funds and the pass throughs are meant to kind of talk to one another. So I think it's hard to conceptualize without talking about pass through. So if I can make a suggestion that let this working group and staff work on this a little bit more, let's present pass throughs and exchange funds together. I think that will clear up a lot of questions.
Good.
I think that would help a lot, because pass-throughs have a lot to do with money that doesn't even count toward primary purpose. And when you see the difference between what an expenditure that is excluded from primary purpose versus one that counts for primary purpose, but not towards allocations, I think that this distinction will make more sense. And the idea of double counting toward eligibility will be less of a concern because it's really only toward allocations where there would be any inequity toward any of the grantees.
And can I ask just also logistical question? I mean, these meetings are scheduled for 4 hours. Is it really just too ambitious to do 2 topics in one meeting? Like next meeting, we're supposed to have pass-throughs and then switch gears and talk about law school clinics, which is totally like different.
I don't think they're very controversial, but they are a little complicated.
Selena, you have a comment about it?
I mean, just to agree with Juan, I think that a lot of these are really dense and we have to rely on Brady to go back and read the statute to us. And then we have to go into the statute. And it does feel like 4 hours, we kind of use a lot of our brain power. So if we could shorten them and even add, I mean, I would be willing to add another one if they were shorter, to kind of break them up a little bit.
Yeah, so that was going to be my question too. If people are amenable, I can look at the work plan and maybe like split certain ones. And so instead of having a 4-hour meeting, maybe we have like a 2.5-hour meeting and really try, because at least for myself, I think I start to lose brain power around that 2-3 hours. It's very hard, especially over Zoom.
It's even harder on Zoom because
Yes.
you can't get up and walk around, but still listen to the conversation. I mean, it's just like, it's very kind of, it's an example of where Zoom works against all of us, I
Yeah.
think.
Well, it's hard when the material, I mean, it's very substantively challenging and dense.
Yep.
Can I
That's
also-
not a great job trying to explain all this, I'll tell you.
So how about, let me take a stab at the work plan, send around some doodle polls and see people like, maybe some meetings can still stay at 4 hours and maybe we try to bifurcate a couple and see what we can do if everybody's amenable to maybe adding 2 meetings this year and shortening 2.
Yeah, and if you could try and make like Fridays at 10, I actually have another standing meeting that
Okay.
the meeting I have to move, but
Okay.
I've moved the ones that were kind of already on the book, but maybe
Yeah.
the other ones starting at noon or something.
Okay.
Yeah, maybe something where we're not, I'll just note 4 hours over the lunchtime.
Yeah.
Like, I think makes it like extra tiring.
Yeah. So
'cause
is
you're,
it
like,
better to do
stuffing
like
it.
is it better to do like a 9 to noon or a 12 to 3 block, something like that?
One or the other, but
Yeah, one or
give
the
us
other.
the
Yeah.
lunch hour.
Yeah. Okay.
Okay, so we're not gonna do anything on exchange funds. Do we need a motion for this? These are both, I'm on both of these working groups, so I'm just like, it's gonna be awesome. So this will be fun. And are there any, before we leave though, are there any other questions about the exchange funds so that when we go back to the working group, Dan and I and the other members can just address them, Zahira and Rich?
I would probably try and just more clearly, I don't know, it got confusing when everything was in this one paragraph. So it's like, here's how you count primary purpose. Here's how you count qualified expenditures. Because there's really, I do appreciate the distinction between the two, but maybe breaking it out into 2 paragraphs within that would be helpful.
Yeah, I mean, that there may be some issues with how it actually gets codified, but if we could break it out for at least explaining it.
Yep, something like that.
Happy to.
All right, I apologize. I have my next Zoom call at 2 and another one at 3.
Oh my gosh, Catherine. Oh, good luck.
So I'm assuming we're not gonna since it's 2:00 now, do we want to preview the pass-throughs? It sounds like.
No, I think we call it. Why don't we just do the in-depth and at the same time? It's
okay. And
meeting.
Dan, you and I and Zahir and Rich will revisit maybe how to simplify this in a way that makes it a little easier for everyone to digest in a short
I look forward to that. I look forward to that.
You're a braver soul than I.
I'm going to do it whether you're helping or not. Your help is going to be good.
I'll try my best. Okay, well, thank you everyone for making the time today. And it sounds like we have some stuff to go to the commission with, and the working groups will kind of finish up on the other stuff. And yeah.
And I just forward everyone I also just forward everyone the notification that went out to programs about expungement. So if you can just review it, that would be helpful. And then we'll
who's on that working group?
because it just was newly formed. We're trying to put our heads together to see what commissioner might have maybe some criminal background or something. So it'll be a combination of some people on the rules committee and maybe some non-rules committee member.
Okay.
Perhaps Justice Murray, he was really involved in like the
That's the
initial
one.
discussion of it. So
Yeah.
we're trying to get him.
Great.
Okay.
Okay, I guess that's it. We can move to adjourn, right?
Move to adjourn.
Awesome.
Okay, thank you everyone. Have a
guys.
good day.
Thank
Bye.
you all.
Have a good weekend.